is there, you know, that there has been a death occasion of the respondent number one who has been represented, you know, Bhagwati and Bhagwanti Industries, represented by Manvati Devi Agarwal. She had died somewhere in 2020, and accordingly, it was left open to us to obtain instructions both for him and for me. So far as I am concerned, my lord, I had written a letter. I pray to be a part of the record, my lord. I've written a letter. It's a registered one with the tracking consignment they have received. If I may just read that, you know. If I may read that. The original is there, therefore it may be kept as a part of the record. May I read?
Yes.
To my client, that's Kaushik Tea Company, we applied under section 37. Sir, madam, kindly take note that in the case under reference, it could be learned on 7/3/2026 from the learned counsel representing Bhagwati and Bhagwanti Industries that Srimati Manvati Devi Agarwal, who represented said Bhagwati and Bhagwanti Industries, had died sometime in the year 2020. This information assumes importance as the period of limitation for filing a substitution petition in arbitration appeal so-and-so would start on and from 7/3/2026. Kindly take note that the matter is listed on 7/3/2026 and is now posted next on 23/4/2026. There has been no instructions and no information from your end, even after filing the arbitration appeal number so-and-so. And as such, it is difficult on my part to appreciate whether or not any cause of action subsists as of now, and if so, whether or not you are interested to pursue the matter. Kindly provide specific instructions to me at so-and-so at the earliest. Consider this letter as extremely urgent. The following is a consignment which has been delivered. In these circumstances, he will be functions official. He cannot represent any further. And so far as my party is concerned, there is nothing on this score and not on merits. Let the matter be closed. It's a joint prayer. So that even if they engage other lawyers later in the day, they can continue the matter. It be closed on this.
I can close it.
Yes, on this count.
Yes.
That
Because
number 2 is there. Here's instructions. And so far as I am concerned, I have written, it is there and there is no instructions. So whom do I go against? I have to find a substitution application.
Yes.
Subsequent to the last order passed by this honorable court,
Yes. Yes.
I again contacted the grandson of the respondent number one. He said that I am not in contact with other partners of the firm, and he is
Respond
not.
number, just a minute. Let me check.
For his order date 7/3/26.
I have gone through the.
Yes.
So respondent number one is the
Bhagwati and Bhagwanti
Kaushik Tea
Industries.
The Kaushik Tea Company is the appellant.
Appellant. Okay, Kaushik Tea Company is the appellant. And respondent number one is
Bhagwati and Bhagwanti Industries,
who has passed away.
represented by Manvati Devi Agarwal. She has passed away.
He has passed away.
Yes. And
So
even,
you are representing respondent number one.
yes, sure.
But since we are stuck in a position, either I can go ahead in view of the death. Otherwise, the appeal would abate. Since there is no response coming, let the matter be closed on this. They can proceed further if need be. So the original may be kept on record. And both the submissions may be recorded.
Learned Counsel Mr. S. Bonik for the
Appellant.
Kaushik Tea Company, and Learned Counsel Mr.
A to D, Dr. A to D.
Dr.
A to D.
Dr. A to D for the
Respondent
for both the respondent.
No, only
respondent number one. For the respondent number one.
Respondent number 2 was the arbitrator.
Arbitrator.
Yes.
The learned counsel representing both the sides has drawn the attention of this court to the order dated 7/3/2026 passed by this court. To stop.
Seven.
wherein it is clearly reflected that the learned counsel, Mr. HOD, representing the respondent number 1, has submitted that as per instructions received from the grandson of, she has passed away, no?
Yes.
Manbhavati, Manbhawati, Manbhavati Devi Agarwal, representing the respondent number 1, has informed that Manbhavati Devi has passed away, full stop. It was also reflected in the order that from the record of the learned arbitrator, respondent number 2, it appears that the respondent number 1 is a partnership firm with 7 partners. As on the date of its registration on 3/2/1996, with the Register of Firms and Societies, Assam. Learned Counsel, next pair, Learned Counsel Mr. S. Bonik has you have submitted this.
Yes, I placed.
You have annexed it earlier, no?
No. This is what we have taken on the 7/3, you know. The registered letter and that is consignment tracking.
Learned Counsel Mr. S. Bonik has submitted that as the period of limitation may expire as the period of limitation was about to expire.
No, it would run on and from 7/3. That was it.
Okay.
It would
As
run
the
on it-
period of limitation was to commence
No.
on and from 7/3/2026,
Accordingly, on 7/3, I wrote the letter.
He then wrote a letter and through speed post
The date is there, you know, 7/3 on the.
and through speed post informed the appellant about the death of Manbhavati Devi Agarwal, who died sometime in the year 2020. Full stop.
Madam, please to indicate that the letter was dispatched on 7/3 and received on 10/3.
This letter, according to the receipt, no, postal receipt, was dispatched on
7/3.
7.
It's there, you know.
Yes.
7/3/2026.
7/3/2026 and was received on
10. That's on the consignment tracking, you know. The last page. The last page. The middle one. Item received.
number,
The last one, you know.
last one,
The item received on 10/3.
and was received on 10/3/2026. The learned counsel has submitted the a copy, original copy of the letter.
Yes, original.
Submitted.
One went and the other one before.
Submitted the letter along with the postal receipt and track consignment
In original.
report. Track consignment what?
No, the postal receipt in original.
Postal receipt in original and the track consignment report.
It's a printout.
To stop the postal receipt along with the track consignment report are marked as X along with the letter and the track consignment report. Letter letter dated.
The date was not indicated. It is there in the postal tracking, you know.
Okay, now dated na like.
Perhaps in the main one it was there. I don't recall.
It's okay. marked as X and will form a part of the record, full stop. There a suggestion for filing a substitution petition was also made through the letter.
Yes. Because 90 days would be there.
Mm.
Then for setting aside another 60 is there.
Mm.
So presently they have the time.
Mm.
But without the instructions, neither can I argue nor we
Mm.
can argue the matter. That's the difficulty.
Yes, yes.
It is not evaded. Not evaded.
It is submitted by the learned counsel that no instructions or information till date has been received from the appellant's side, full stop. The learned counsel for the respondent, Mr. A to D, has also submitted that he has also not received
Not receiving.
any information from the respondent's side, full stop. On this aspect, it is submitted at the bar that this matter may be closed
Closed. At this stage,
at this stage.
leaving it open
Mm.
for other, I mean, it can be reopened
Leaving
by filing appropriate applications, whatever.
Yes.
By filing
leaving an
appropriate applications
option to be
Parties will be
reopened,
for liberty.
leaving an option, leaving according a liberty
What
or
could be
leaving
wrong?
an
Could be
option.
wrong. The matter may be closed,
Uh,
parties would be at liberty
Mm.
to file appropriate application if need be. That will be
full
said.
stop. Okay. Considering the submissions at the bar, comma, as no as as Manbhavati Devi Agarwal has passed away and as no instructions has been received by both the parties relating to her demise, comma, this matter is closed on this aspect alone at this stage, full stop, comma, with a liberty to file an appropriate
The
petition.
parties are at liberty to file appropriate
Full
applications
stop,
if
yeah,
need.
full stop. With a liberty, the parties are at
Yeah, no?
liberty to
Mm.
file an appropriate petition,
If need be.
if any.
Grateful.
Let me check the arbitration
No,
file.
yes, it was the arbitrator's award was assigned under 34,
Ah.
34 dismissed. We came in 37. Pendency 37, a partnership firm and the appellant company is there.
Mm.
2020 died. They did not bring on record.
Mm.
Now when on 7/3 they bring on record, they do not tell us who the other partners are.
Understand.
In these
But
circumstances,
I'll just check.
yes, Lordship may take.
I understand. I believe
That is-
that I've already closed
Correct.
it. I'll just
Okay.
check the arbitration record.
Grateful,
It will mark X query
X.
Then on the last page, I'll mark as X, not the 2 pages.
Procedure.
Did it arrive at any settlement?
No, it was an ex parte award, Lordship.
I have no instructions actually.
Hmm.
So my letter was very specific
Hmm.
that I need instructions to whether they want to pursue the matter or not. But the one thing would be that he pointed out, Lordship may please to pass an order transmitting the record to the concerned court.
Oh, yes.
That has to go.
Yes.
We'll send back the records.
Yes.
It doesn't say that.
Return the records to the concerned. These are all original records.
Yes.
Return the original records to the concerned courts.
No, Lordship.
Concerned court.
Concerned.
Thank you for reminding me. I have totally forgotten. Yeah, otherwise it will be lying here and maybe we'll lose it also. It will get lost in the record room. These are all original records. Mm. Send back the original records from the concerned court to the concerned court.
Much of it.
তুমি অর্ডারটো দিওঁতে ৰেকৰ্ডটো লগতে দি দিবা হা আৰু এবাৰ মই চেক কৰি ল'ম হা অৰ্ডাৰ দিওঁতে মানে বৰ্ডত নিদিবা ৰেকৰ্ড লগত দিবা
Yes, I'm appearing for Miss U Chakrabarti. Lordship, Learned Council is not well. She is suffering from.
Just a moment. মমি এইটো ডিসপোজ অফ বুলি লিখি দিওঁ নেকি এইটো এটা লাইন এটা দি দিবা ইন টাৰ্মছ অফ দি above observation this appeal stands disposed of the last of the ৰেকৰ্ড লগত দি দিবা হা
Lordship, matter may kindly be passable for the day.
yes
Your Lordship, note.
কোনটো আছিল আইটেম নম্বৰ
And
Learned
item
Council,
number
miss,
10,
your name?
Miss U Chakra. I am appearing on behalf of Miss U Chakrabarti.
your name
P. Khaklari.
Learned Council Miss B. Khaklari has paid for adjournment on behalf of Learned Council Miss U Chakrabarti,
U
who
Chakrabarti.
is not well.
Yes, Miss Lordship. She is suffering from viral fever.
As she is suffering from viral fever, লিখিলে হৈ যাব Learned Council Mr.
A Dev,
A. Dave is present on behalf of Learned Council Mr. D.
D.
Rathi.
Rathi.
List this matter dated. You wanted date?
After 15th of May. 16th.
Your Lordship, a fixed date.
Dated 21st.
Much obliged.
Deeply obliged. Huh?
Much obliged.
Yes, item number 10.
Same order. খালি ইয়াত D. Rathi টো নিলিখিলে হ'ব
Lordship, in item number 10, I'm for the respondent.
Okay. Item number 10. I'll mention your name.
Yes, M. Sharma.
Learned Council Miss M. Sharma is present. D. Rathi নহয় huh? Okay. No objection.
Lordship, can the board matter be fixed on same date?
Same date, yes. Can be fixed.
19th.
Yes.
Deeply obliged. Deeply obliged.
21st of May. Items. Yes, your item also, 21st of May. Correct?
Item 11. Item number 11.
Parties are not represented, please just matter after 2 weeks, did you hearing or not? On failure of appearance of any of the parties, necessary order may be passed. Hearing or to be done. Out of old pending case,
Item 12.
comma did as this is an old pending case. May please.
I appear for the respondent reviews in this matter. Before she starts arguing her matter, I would like to point out to your Lordship one aspect of the matter. If I don't bring it to your notice, my lord, I'll be failing in my duties. Probably this matter doesn't require a detailed hearing. Probably it has to be sent back to remanded back to the tribunal again, because our High Court, my lord, following decisions of other High Courts, have come to a conclusion that a single bench of the tribunal, that is the RCT, cannot decide a matter that is fixed before it. So it has to be decided by a division bench. Now, in this particular case, my lord, the judgment which is impugned, my lord, lordship will find that at page page 30, my lord. Lordship will see the quorum at the top of the
Page 30.
30, my lord. At the quorum, my lord, at the top, my lord, the quorum is reflected. Mr. B.B. Verma, honorable member, technical. It's a single bench. It's a just bench presided by a single bench, my lord. So now the judgments which our High Courts have passed on this aspect, my lord, I would just like to place it before your lordships, my lord. There are several judgments. I am relying on two only, my lord. In one of the matters, my learned friend was also a party. So,
You are for railway tribunal.
no, I'm for the respondent
You
railway.
are for the respondent.
Railway. Tribunal is an independent authority.
Hmm.
So if lordship takes up MFA number 90 of 2013, my lord, this is the first judgment.
Okay, yes.
Lordship may come to turn to the next page, my lord, paragraph 5.
Hmm.
May I read out, my lord?
Yes, please.
The learned counsel for the respondents fairly submitted that earlier by an order dated 9/7/2015, the division bench of the Gujarat High Court in Union of India through General Manager and others versus so and so others in special civil application number so and so, basing on the decision of the apex court in the case of Amulya Chandra Kalita, where it was observed that every bench of the tribunal must consist of a judicial member and an administrative member, has held that the administrative member alone could not have heard and decided the matter. He further submits that based on the above observation, the learned single judge of the Gujarat High Court, by an order dated 27/8/2018, passed in our first appeal number so and so, between so and so, observed that the claim application could not have been decided by a single member, bracketed technical. This order dated 27/8/2018 was challenged before the Supreme Court in civil appeal number so and so, in between so and by an order dated 7/1/2025, the Honorable Apex Court has dismissed the SLP, thereby upheld the order dated 27/8/2018. In the light of the above decision, the learned counsel for the respondent submit that the matter may be sent back to the learned tribunal for first trial on the matter consists of two members, one judicial and one technical. Mr. So and so, learned counsel for the appellant, considered with the submission of the learned counsel for the respondent, and in view of the above decision of the Honorable Supreme Court, he has no objection if the matter is remanded back to the tribunal for fresh adjudication. In the light of the above, and as held by the apex court in the above case of Union of India versus minor Sumit Suresh Sharma, the impugned judgment and order dated 28/12/2012 passed by the learned Railway Claims Tribunal, Gauhati Bench, Gauhati, in claim application number so and so is hereby set aside and quashed. The matter is remanded back to the learned Tribunal, Gauhati, for fresh adjudication of the claim petition on merit, my lord. The other judgment, your lordship may kindly take up MFA number 113 of 2016. In this matter, my learned colleague was appearing for the respondents. Following this decision, another decision has come, and there are other decisions also following the original one. So, my lord, lordship may come to paragraph number 6.
Okay.
I'm just reading
Yes,
out the
yes.
reading out the relevant portion.
Yes.
Accordingly, taking note of the submissions of the learned counsel for both the parties and also the decision of the Honorable Supreme Court in Amulya Chandra Kalita Supra and the decision of a coordinate bench of this court dated 8/5/2025 in MFA number 90 of 2013. The judgment which I just relied on, my lord.
Hmm.
The impugned judgment and order dated so and so stands set aside and quashed. The matter stands remanded to the tribunal with the direction to constitute a bench comprising of one judicial member and one technical member, and to dispose of the same after affording opportunity of being heard to both the parties.
So here, where is the bench? Page
Lordship
30.
may come to page 30 of the
Okay.
the quorum is
Yes,
reflected
yes.
at the top, my lord.
Yes.
Mr. B.V. Verma, Honorable Member Technical. It was heard by a single judge, my lord,
Mm.
single member. So it cannot hold the film. It has
Yes,
to
what
be-
do you have to say?
Lordship, first of all, the submission made by the learned counsel for the respondent is based on the power of the member, Lordship. In terms of section 4 of the Railway Tribunal, Railways Act 1987. Railways Act. My lord, first of all, Lordship, my submission would be that here the manner in which the investigation was conducted
Mm.
is contrary to the provisions of rule number 7 and 10 of the Railways Procedure.
Yes, dear Kitapu.
And this issue was set in rest by the Honorable Supreme Court, my lord. I have the decision of the Honorable Supreme Court.
Mm.
Railway passengers' manner of
What she
investigation.
is arguing is on merits, my lord.
Even though if the matter is remanded back to the tribunal, the fact is, my lord, the manner in which the investigation of this case was conducted, that is in contrary to the rules 7 and 10 of the Railway Passenger Manner of Investigation of Untoward Incidents Rules 2003. My lord, here I have been waiting for this case for last 7 years, my lord. My husband was died on 14/7/2017. I'm a poor lady, my lord. I have nothing to survive on my own, my lord. I have my one son, my lord. So my case is that if the investigation is not conducted in terms of the rules, my lord, and this issue was already decided by the Honorable Apex Court, then this matter may be allowed, my lord. Because even though if the matter is remanded back, the fact is, my lord, they have not conducted the inquiry within 60 days. The law
No, but
says,
you see, that
my lord,
she's
kindly
right,
see.
no, that is on merits.
Whether
That
your lordship
tribunal
will
will
enter into
decide.
merits of the case, my lord,
That
after the
the,
judgment, my
at
lord.
least the bench, the appropriate bench will decide in the tribunal. You see, there is a judgment of the Supreme Court that you have to have a judicial member and a technical member.
But I have another decision of the Supreme Court where the Supreme Court do not go that the merit of the case and decided the matter based on
My lord,
the.
in one matter, she
provision.
argues on this aspect, my lord,
This
saying that
with
this is.
regard to refund of goods, my
She
lord.
was
This
the
is the
counsel in
accident.
this.
This is correct. I have not denied that.
What kind
But
of
my lord,
submission is this, my
but
lord?
my lord, since
She will
this is an
appropriate and
accident
inappropriate
case,
at the same time. Whenever it is convenient to her, she will argue that a single bench cannot.
No, she has a ground because you see, he's been waiting for 7 years.
Yes, absolutely. I do not deny that fact, my lord. But whether your lordship can enter into merits of the case, my lord, for
I
the
don't think so. I don't think so.
you cannot, my lord.
lordship,
Can I
then
enter into merits of this case
lordship,
now?
if lordship matter is remanded to the tribunal, then lordship kindly this or submission may be recorded in the order, lordship.
Sure.
A time limit may be fixed for the tribunal to dispose it of, my lord.
Because here the DRM report was submitted just after 2 months of filing of the
You
case.
give
my
me
lord.
a judgment. You have stated that this matter is put to rest by the Supreme Court. You want this to be recorded?
Yes, madam.
The DRM report will always be filed once the case is filed before the tribunal, my lord.
But here the rule
Until
says
and
that
unless-
they have to submit the report within 60 days and they did not file that DRM report.
So see, this comes within the rules, no?
Yes.
Probably
So
she
then
has
it will
missed.
be on the merits.
My lord, if my submission may be recorded in the order,
Yes.
it will be helpful, my lord.
My lord,
This,
a DRM report is prepared by the railway authorities and that is required to be prepared within 60 days. That was prepared. What she is saying that report was filed before the tribunal after expiry of 60 days, my lord. Obviously, my lord, only when the notice goes to the railway respondents, they will come and file the report, my lord. It's not that they have not done it in time. They have done it in time. The authorities, they have prepared it within the 60 days limitation period. But while filing it before the tribunal, it can be filed only when a case is filed, my lord. The case might have been filed after 2 years, my lord.
My lord, claim application was filed on 3/8/2017
17.
and they have submitted their report on 27/2018. Sorry, 19/7/2018. And in the judgment,
claim application was filed on?
3/8/2017.
There is no limitation
And my
prescribed
lord,
for submission.
And the report was filed on?
report was prepared on 19/7/2018. And in the judgment, my lord, the Supreme Court judgment says that,
Which
my lord,
paragraph?
this is a very short order, my lord. May I read, my lord?
Yes, which paragraph?
Paragraph 2.
Okay.
Though Rule 27 of the Railway Passengers Manner of Investigation of Untoward Incidents Rule 2003, hereinafter referred to as rules, mandates the railway authorities to investigate into such an untoward incident. Admittedly, no such inquiry was conducted immediately after the incident. It is only when the appellants filed the claim before the RCT on 27/2/2009 that investigation into the incident was ordered on 23/4/2009. According to the railways, the said investigation revealed that the deceased detained from the moving train at D cabin without stoppage of the train and invited the accident. The claim was rejected on the aforesaid basis, and the aforesaid plea of the railway was accepted by the RCT, resulting into the dismissal of the claim of the appellants. The appellants filed the appeal, that is FAO number so and so, challenging the aforesaid order of the RCT. The High Court has dismissed the same by cryptic and non-speaking order, with the only observation that findings of the tribunal in the impugn award and the reason assigned in support of the same do not warrant any interference. It is in this circumstance the appellants are before us in these proceedings via Article 136 of the Constitution. After hearing learned counsel for the parties, we find that it is not even necessary to go into the issue as to whether it was the fault of the deceased or that he accidentally fell down. Learned counsel for the appellant has drawn our attention to the provisions of Section 124A of the Railways Act 1989, which warrants payment of compensation whenever untoward incident occurs, whether or not such an incident has occurred by any wrongful act, neglect, or default on the part of the railway administration. Going by the aforesaid provisions and the peculiar facts of this case, where no inquiry as mandated by the rules was conducted immediately after the incident had occurred, we are of the view that the appellant shall be entitled to compensation payable under Section 124 of the Railways Act 1989. We are informed that this is the observation passed by this court. Here, accident was occurred, ma'am, 14/7/2017.
In the instant case?
In the instant case. 14/7/2000, the accident was there, the late Harendra Das was died, my lord.
Hmm.
And they have prepared the report on 19/7/2018, almost after 1 year, my lord. Here, the Supreme Court says that immediately after the incident, they have to submit the report within 60 days, as per Rule 7, my lord. So my humble submission would be, my lord, since this legal issue is already set in rest, my lord, and even there, the single judge did not have the power to adjudicate the case, my lord, if the matter is remanded back to the tribunal, then only the fact remains that they did not submit the report within the prescribed period, my lord, period of limitation, my lord. So I have been waiting for last 7 years, my lord. I'm a poor lady, my lord. My husband died. He was a labor in the poultry farm, my lord. So, my lord, I have only one son. So I am just waiting for this case to just dispose this matter, my lord. So if this matter is remanded back, then again it will take a time, my lord, to dispose this case. my lord.
It's not that only based on that report, the matters are decided before the time, my lord. If she wants to argue on the merits, let her argue, my lord, I'm ready. Then thereafter, she will not be able to take that ground that it's required to be remanded back. my lord. There are number of Supreme Court judgments, my lord, on this aspect, saying that it's the duty of the appellant or the claimant to
Now, let
prove.
me ask one question first.
my lord.
See, this report was prepared after 1 year,
That I'm not sure, my lord.
Yes,
but you have said no, it was prepared within 60 days.
my lord, I'll have to go through that. I've not gone through that when it was prepared, but it's not that it's based on that report only the matters are decided. In Rina Devi, recently, it's a larger bench decision of the Honorable Apex Court, my lord. It has said the onus is always on the appellant or the claimant to prove that the person concerned had died in an untoward incident.
Yeah.
Where is that evidence? All these reports and other things come second, my lord. That's why I'm saying that it has to go back to the tribunal. And whether your lordship would like to enter into merits of the case, my lord, in such a
And then they send it to the tribunal.
tribunal, my lord, and lordship will direct the tribunal to dispose of the matter within a limited time, my lord, fixed period, within a fixed time frame, my lord. Because there is no decision of the tribunal, legal decision. What your lordship will decide, my lord? What your lordship will examine, my lord? This is not a valid judgment, my lord. In an appeal, lordship will only examine the correctness or otherwise of the decision of the courts below, my lord.
You see, when the wrong forum decides a case, we'll have to place it before the proper forum.
So that is the thing, my lord. What
We
your
are-
lordship,
we cannot get into the merits.
because this is an appellate forum, not a trial court, my lord.
Let the matter be remanded back and my lord, timeline may be given to.
Absolutely, my lord. I do not have any objection with
And
regard to
lordship,
that aspect, my
if,
lord.
this submission may be recorded, that will be helpful, my lord.
I don't
Or
want to record the
my judgment
submission.
may be
Then
done.
I'll have to get into all the details. Actually, I do not want to record
That
this submission.
amount to influencing the tribunal, my lord.
Hmm?
That might is a amount to influencing the tribunal, the trial court, my lord.
No, that is not the ground. Because then I'll have to get into all the
Yeah.
into all the merits. If I'm getting into one merit, then I'll have to get into all the merits. Whether there was sufficient evidence that the incident was not an armed war incident. This is the main decisive factor according to section 124. So then we'll have to get into the merits in detail. So I don't want to record it. And if it is okay, then I'll remand it back. And if it's not okay, then I'll get into all the details. You decide, it's up to you. Now ball is in your court. You tell
The
me.
tribunal any give up permit.
Let the matter be remanded, my lord.
Remanded. You see, why I'm saying, we'll give a timeline.
Yeah,
And I'm
absolutely.
also concerned about the lady who has lost her
Definitely, my lord.
husband.
I'll never object to that, man.
Who knows what you'll do in the tribunal? You will raise objection. You
I'll
have
not be
already
there.
raised objection here.
I'll not be there, my lord. There are many things out there in this case. I don't want to point it out before you
But the judgment which was delivered by the single member is purely based on the DRM report submitted by the respondent, my lord. The case is that.
Let it go.
But you see, if you
Let
claim
it
a
go.
wrong charge, you can pass any order. I can pass an order. The appellate court can pass an order if the charge is framed in a wrong manner. But if the forum is wrong altogether, then you will have to send it to the proper forum. That is the problem.
Even if the DRM report goes, my lord, they will have to prove their own case. That evidence is not there, my lord. So it will be better for them if they approach the tribunal again. They would be able to lead evidence. No?
Where is the Amulya Kolta's judgment quoted in full? In which one? The first one or the second?
First one is 90 of 2013.
In there, the Amulya Kolta's judgment is quoted, no?
Supreme Court judgment is,
Suresh.
yes. It's based on two decisions, one Gujarat High Court and the other one is of the Honorable Apex
Okay.
Court. That Gujarat High Court matter went up to the Supreme Court. The SLP was dismissed. Based on that, following that, our High Court has taken the decision. And following 90 of 2013, 113 of 2016 was also delivered.
Our learned counsel, Ms. M. Sharma, no?
Yes.
For the appellant, Ms. Kaushalya Das. And
B. Sharma.
learned standing counsel, railways.
Railway Council.
Learned-
Because that panel has been dissolved in February 2022. We have been allowed to continue with the matters that were left with us, my lord.
Okay. Learned Railway Council, Mr.
B. Sharma.
B. Sharma. For the. Who is the respondent here?
All the response. You take it, Allah. All
One
the
respondent
response.
only.
All the response.
For the respondent. Full stop. It is the appellant is aggrieved by the judgment dated 12/4/2019 in connection with এইটো পেজ হেৰিত আছে 30ত আছে এই আন্ডাৰলাইন কৰি থৈ আছে ক্লেইম এপ্লিকেশ্যন নাম্বাৰ OA এনেকে লিখা আছে
Roman 2U/GHY/116.
অল নিউ দুটা লিখি দিবা হা অল নিউ দুটা আছে পেজ 30 হা আৰু পেন্সিল দি আন্ডাৰলাইন কৰি লিখা আছে আৰু টিক মাৰ্কো দি থোৱা আছে অল নিউ দুটা লিখা OA Roman 2 U এইবোৰ গোটেইখিনি লিখি দিবা হা 2017 old or 2017 new. The in an unfortunate incident, the husband of the appellant, Parendra Das, died on 14/7/2017. Full stop. Compensation was paid for by the appellant, which was dismissed by the railway by the Railway Claims Tribunal, Gauhati bench. Full stop. The learned counsel for the respondent has submitted that the single member of the bench is not eligible to cannot decide is not eligible now cannot decide
A single bench of the tribunal cannot decide.
Single bench of a tribunal cannot decide a claim application as it goes against the guidelines of the decision of the Honorable Supreme Court in as it goes against the guidelines decision of the Honorable Supreme Court
As has been held by the
Union of India versus Minor Sumit Suresh Sharma.
Yes, sir. My submission is, my lord, if I may just clear.
Can you give me the citation?
That is not a reported case, my lord.
Okay.
My submission is based on our High Court decision. Our High Court has in MFA number 90 of 2013 held that a single bench of the tribunal cannot decide claim applications listed before it.
As
It has to
been
be a
decided
division.
by this court in
MFA number 90 of 2013 and MFA number 113 of 2016. Those two decisions. And these two decisions have relied upon the Supreme Court decision.
লিখা দুইটা MFA number এইটো হেৰি পাৰ্টিৰ নাম কিটাও লিখিব লাগিব ইন হেৰি ইন MFA number 19 আগত এইটো ভৰাই দিবাচোন দেই in Union of India versus MS Shri Mahalakshmi Mills MFA number 90 of 2013 and decided on likhiba decided on 8/5/2025 and UOI versus MS Bajaj Steel in MFA number 113 of 2016 decided on 18/11/2025. So it is submitted that both these decisions, both these orders have been passed after relying on the decision of the Honorable Supreme Court in which case?
In Amulya Chandra Kolita and a decision of the Gujarat High Court.
No. You give me the entire citation. Amulya Chandra Kolita, then
And
versus who and citation what, decided on what, case number what?
In special civil application number 2602 of 2013, basing on the decision. Well, I'll give the, after some time, I'll give it to the court
Yes.
master Malik, the decisions. On of the apex court and the Gujarat High Court's decision, following which our High Court has decided. Lordship may keep
It is,
that
next
space
will-
blank.
Yeah, we'll keep it placed. In this instant case, it is apparent that this case was decided by a single bench of the tribunal. Full stop. The learned counsel for the appellant has, however, raised objections stating that that what was not submitted within 60 days?
The DRM report.
Oh, the DRM report as per section 7 of the,
Rules 7 and 10 of the
as per rule 7 and 10 of the
railway passengers in bracket manner of investigation of untoward incidents rules 2003.
Itu yet 9 heading. 9. 2003, 9. 2012, 12 possible.
Passengers manner incident rules 2020.
2020. You are referring to rules 2003.
Yes.
That rule has been repealed, already repealed.
Which one?
2003
This
rules.
is this book is
Now
from
in-
2016, my lord. Publishing year
Now
is
a new rule has come
2016.
in,
2020.
2020.
Or there are many rules. 2017.
Yes, my lord.
But we do not have the rules. It comes through of notification, so we do not have the rules.
No,
This
after
rule was not
this
repealed.
manner of investigation rule,
Hmm.
it was modified in 2020 only. The original was 2003.
No, but it will go according to the original. No, this is an old case. It will not come according to 2020.
Presently, that has been repealed.
Hmm.
That is what I'm saying.
Rules 7 and 10, my lord.
Rule 7 and 10 of
The railways passenger manner of investigation of untoward incident rules 2003.
এইটো manner of investigation and untoward incidents. এইটো within bracket লিখি দিয়ে। এইটো তেনেকে থাকি লিখিব লাগিব।
7 and
10.
It is submitted that the railway passenger Harendra
Das.
Das, no?
Yes.
Harendra Das.
Yes.
Harendra Das died on 14/7/17 due to a accident while he was traveling in a train, and whereas the DRM report was prepared on 19/7/2018.
2018.
It is 14/7/2017 asa, and it report to 19/7/2018 asa. Post of the appellant has a good case, and even if the matter is remanded on the ground of being tried wrongly by a single bench, and the fact that the DRM report was submitted after 1 year instead of within 6 months,
Within 60 days. my lord,
or
the
within
report has
60
to be
days, within
submitted
60 days,
after the date of incident.
60 days after the date of incident, will go against the submission of the learned counsel for the railways, full stop. On the other hand, the learned counsel for the railways has submitted that at this juncture, when the appropriate forum has not passed the impugned judgment, it is not necessary to get into the merits of the case, full stop. I have considered the submissions at the bar with circumspection. It has been held by this court in C. Mahalakshmi Mills Supra that it paragraph 567 bhai diba. Okay. Paragraph 567 and in MS Bajaj Steel Supra that এইটো হেৰি এন নহয়, এইটো ইয়াৰ পিছত আকৌ এইটা paragraph 6 and 7. Reverting back to this case, it is held that in the light of the decision, reverting back to this case, it is held that in the light of the decision of the Honorable Supreme Court in Omilla Chandra Kolita, is it the correct name? Omilla Chandra Kolita
Yes, sir.
Tupra. This case is also remanded back to be decided by the appropriate bench, consisting of appropriate forum. All right? Okay. Anything to be added or? Okay.
Remanded back to the appropriate forum to constitute a bench consisting of a judicial and a technical member. There are two members only.
Yes, yes, that will be better. Appropriate bench to constitute an appropriate forum consisting of a judicial member and a technical member, whose of this matter is to be decided within
6 months.
as expeditiously as possible. Okay, because there is another direction from the Supreme Court not to confine the months. Okay, I'll come back. I'll come back after 5 minutes.
Please proceed.
My lord, 28 years boy,
Hmm.
28 years boy, who was my lord unmarried, my lord.
Hmm.
He died in a motor accident, my lord. And the learned tribunal, my lord, awarded total compensation amount only 5,64,800. Taking, my lord, monthly income of the deceased, 3,500. The judgment was passed, my lord. Judgment was passed, my lord, 2019, my lord. My submission before your lordship, my lord. As per my lord evidence, PW, my lord, he is the father of the deceased. The victim boy was working in a Tusk Plastic Industry, Chennai, and he has, my lord, 20,000, 15,000 monthly income, my lord. And the learned tribunal, my lord, it was held, my lord, only, my lord, 3,500. That is the main ground. On the other hand, my lord, regarding, my lord, love and affection, pain and shock and suffering, my lord, a small amount has been awarded, my lord. He is the, my lord, only son of the parents, my lord. 20 years old boy, my lord. And now, my lord, the parents, my lord, has filed this appeal, my lord.
Yes. Both the parents?
My lord,
Both the parents have filed the
my
application.
lord, my learned tribunal, my lord, awarded, my lord, compensation amount.
Married or unmarried?
Unmarried, my lord. He was unmarried, my lord. My lord, PW1, he is, my lord, Primit Momin. He is the, my lord, father of the deceased, my lord. He, my lord, deposed before the tribunal that he was working in a plastic
PW1.
industry, and 15,000 was his earning, my lord. My lord, in fact, my lord, no income certificate was produced before the tribunal, my lord. My lord, at least, my lord, 3,500, very nominal, my lord. And my lord, their only son, my lord, died in accident, my lord. My lord, this is the case, my lord, very simple case, my lord.
Yes.
My lord, in this regard, my lord, I have, my lord, citation, my lord, 2014 to HCC 735, Soyad Sadiq and others. My lord, this is a judgment, my lord. Here in this case, if any income proof has not been submitted before the tribunal, that the income of the deceased was held 6,500. My lord. My lord, this is the case, my lord.
Okay.
My lord, this is the case, my lord. Mainly, my lord, and
Which paragraph?
my lord, particularly paragraph number, you will kindly see 9, my lord. Page 741. My lord, here in this case, he was a vegetable vendor, my lord. Vegetable vendor, and Supreme Court held 6,000, 5,500 per month. Well, this is like a very simple case, a very small case, my lord.
Lordship, income, they are saying PW1 said that he was working in some place that there in that Siddiq case, Lordship, vegetable vendor, it was proved that he was a vegetable vendor. Naturally, a vendor don't have a income. But here, in this particular case, the court has come to the correct finding, Lordship. At paragraph
5, Roman 5, page 13 of memo of appeal. In the matter in hand, the version of PW1 is not supported by persuasive documentary evidence on record to conclude that the deceased was earning some amount of money monthly. But in absence of
Which
convincing
paragraph?
Lordship, para 5, Roman 5,
Yes.
page 13, Lordship, of the
Okay.
memo of appeal, Lordship.
Okay.
In the matter in hand, the version of PW1 is not supported by persuasive documentary evidence because what PW1 said that he was working in a plastic industry somewhere. So naturally a salary certificate will be there, but it was not there. The deceased was earning some amount of money monthly, but and not even a Lordship employment document that he was employed somewhere. But in absence of convincing evidence, it would be unjust and improper to draw inference that earning of deceased was rupees 15,000 per month. In contrast, it would be justifiable to visualize that the income of the deceased was rupees 3,000 per month, 3,500 per month. And accordingly, the calculation was made, Lordship. And Lordship, about their ground, about love and affection and pain, shock and suffering. In that case, Lordship, pain, shock and suffering, they do not get. The court has given that is in excess. Lordship will find at page, internal page 14, Lordship.
Okay.
Court has given 25,000. That is wrong, in fact. And also loss of love and affection 15,000. That is also wrong, Lordship. Pronicity, I will show pronicity very clearly at times. Yes, Lordship. So these amounts are already extra given, Lordship.
Page of proceeding, which paragraph?
Para 54, Lordship. I'll read that. Why I'm showing this, Lordship? Already the court has given more than what is necessary,
I
what
know.
is the settled. Because the judgment was passed in 2019. Pronicity came in 2017 itself.
Yes.
54, para 54, Lordship, got it. As far as the conventional heads are concerned, we find it difficult to agree with the view expressed in Rajesh. It has granted rupees 25,000 towards funeral expenses, rupees 1 lakh loss of consortium, and rupees 1 lakh towards loss of care and guidance of minor children. And in the present case, there is no minor children. So the head relating to loss of care and minor children does not exist. That is the finding. Though Rajesh refers to Santosh Devi, it does not seem to follow the same. The conventional and traditional heads, needless to say, cannot be determined on percentage basis because that would not be an acceptable criterion. Unlike determination of income, the said heads have to be quantified. Any quantification must have to be reasonable foundation. There cannot be a dispute about the facts that price index, fall in bank interest, escalation of rates in many a field have to be noticed. The court cannot remain oblivious to the same. There has to be a thumb rule in this aspect. Therefore, there will be extreme difficulty in determination of the same, and unless the thumb rule is applied, there will be immense variation lacking any kind of consistency, as consequence of which the orders passed by the tribunals and courts are likely to be unguided. Therefore, we think it seemly to fix reasonable sum. It seems to us that reasonable figures on conventional head, namely loss of estate, loss of consortium, and funeral expense, should be rupees 15,000, rupees 40,000, and rupees 15,000 respectively. The principle of revisiting the said heads is an acceptable principle, but the revisit should not be fact-centric or quantum-centric. We think that it would be cunning that the amount that we have quantified should be enhanced on percentage basis in every 3 years, and the enhancement should be at the rate of 10% in a span of 3 years. We are disposed to hold so because that will bring in consistency in respect of those heads. In our case, Lordship, that loss of consortium 40,000 is for wife. But in our case, only the mother gets. Sarla Verma Lordship knows that when parents are filing, only the mother is considered.
No, but in the new case, Sushila Agarwala, I forgot the case.
Acha.
In the new case, latest case, both the parents would get parental consortium, both the parents will get.
But
I forgot the
Lordship,
case.
no, Lordship, but the prononciety is of a constitution bench, 5 judges judgment. So this will always be, Dawoodi Ibrahim judgment, Lordship knows that what the larger bench says, that is to be followed by the, so any other benches giving any kind of, that is why in prononciety this is mentioned, Lordship, there will be different kind of by different courts.
Not Sushila Agarwal's case, it is, I think, some insurance company's case. It came out in 2020. I think it's the same bench, three bench, I think.
No, this was 5, Lordship.
Or this was 5, no?
Yes, Lordship. This was a constitution bench, and that is why in 54 it is mentioned that there will be immense variation, lacking any kind of consistency, as a consequences which the orders passed by tribunals and courts are likely to be unguided. That's why this guidance was given. So if after that also some courts are giving to, that won't be, because Dawoodi Bohra says that larger bench,
Yes,
the court have
it
to
always,
always that gets precedence over any other kind of
true.
and we being in the High Court, we have to naturally follow the Supreme Court's the larger bench, and this was a constitution bench, Lordship. 5 judges prononciating. So
then it will keep on increasing after every 3 years.
every 3 years, 10% increase.
Mm.
But in 2019, Lordship, that was not, it had not increased. So the court was the amount, because the judgment was passed in 2019. But Lordship is talking about now if the judgment is. That I'll leave to Lordship. But I have read the part which is relevant for the decision, Lordship.
I have forgotten the judgment. There is a parental consortium also for both parents. I forgot the bench.
I'll check Lordship
I
is
forgot
saying
the strength
2020.
the bench. I think the first party is the
No,
insurance.
and
Appellant is
after
the insurance
prononciety, Lordship, no
After
constitution,
prononciety.
no constitution bench has taken
I
up
forgot
MSc
the
case.
strength of the bench.
Okay. I'll try to check, Lordship. 2020, Lordship.
Actually I didn't look for the strength of the bench.
Okay. I'll check, Lordship, what is the case,
Mm.
if Lordship, when Lordship is saying that.
My lord, only my lord,
It's very specifically mentioned that parental consortium, then filial consortium, then different types of consortium.
Lordship is talking about Megma,
Yeah, correct. Megma insurance.
Megma insurance.
Mm.
But let's
What is
that
the
is
strength of the bench?
two judges.
Two. Okay. I didn't look for the strength of the bench.
Yes, 2 judges.
Mm.
So ultimately,
But
I'll
you
I'll
see,
leave it to Lordship. But the thing
here
is,
they have not. Here it is not decided that both. What about the other judgment you're talking about, Sarla Verma?
Sarla
What
Verma.
is the strength of the bench there?
Their Lordship, I think 3. I'll just check. I have the judgment.
So then only mother gets the.
Only mother, and that was upheld by pronunciation on those parts.
even judgment. Sarla Verma.
3
Even
judges.
Three bench
Yeah.
judgment.
3
My lord,
judges.
hearing this, my lord, of PW1, my lord, he has in the cross examination, he has clearly stated his son was working as a labor in the outside of Assam, my lord. My lord, my submission before your lordship, my lord, a young boy, 20 years old, he is working, my lord. My lord, only
Just let us go through the paragraph. Please read the entire paragraph.
my lord,
Paragraph 9.
my lord, I am saying, my lord, as regard to my deposition of the PW1. my lord.
No. Paragraph 9 of Syed Sadiq and others.
Yes. Paragraph 9, my lord. May I read, my lord?
Yeah.
There is no reason in the instant case for the tribunal and high court to ask for evidence for monthly income of the appellant claimant. On the other hand, going by the present status of economy and raising price in the agricultural products, we are inclined to believe that a vegetable vendor is reasonably capable to earning 6,000 500. My lord, hearing this, basically, my lord, the judgment has been passed. Deceased was a vegetable vendor, my lord. Hearing this case, my lord, he was a, my lord, laborer. My lord, 3,500, very nominal,
This is
my
a
lord.
long judgment. You have anything about income when not shown in pronoicity? Because everything has been covered in this case.
Yes.
You have anything relating to income?
In pronunciation, income,
Mhm.
lordship, no,
This is
income
not
is
covered.
not covered.
My lord, I
It
think, my
has come to the calculations, in fact.
Mm.
Pronunciation is basically calculation
calculation.
and future prospect and
Yes,
the-
yes.
because lordship will find pronunciation, the findings are in the end, lordship.
Mm. I
Uh,
have read the judgment, but
yes.
forgotten actually.
The findings, lordship, because we proceed to record the conclusions are at paragraph
I know
51.
those part I have read.
Huh.
Even, my
So
lord,
these are
Those
the
part I
things.
keep reading.
Every case
repeatedly,
it
yes.
comes.
even, my lord, a coolie, my lord, in respect of a coolie, above paragraph, my lord, the Supreme Court held 4,500. My lord, he is a young boy, my lord. He
So
said,
labor lordship, if labor, he is saying that coolie 4,000. Okay, 1,000 lordship can increase, but not vegetable vendor lordship. Okay, but then they did not prove that he was even working, because what was their evidence was that he was he was working outside of Assam somewhere. So naturally there will be an employment document first
no,
of all.
no documents I have not produced.
You have not, that is what I am submitting, that there will be naturally that they did not produce that. So the very factum that he was working is doubtful. But still lordship can increase by 1,000 rupees, no issue with that, lordship.
Oh,
So
my lord.
he is saying coolie 4,500 because he is also saying the PW
Plastic.
one has said he was labor, lordship.
My lord,
So-
my submission before lordship, only basically, my lord, this appeal has been prepared on monthly income of the deceased. My lord, 3,500 judgment has been passed in 19, my lord. My lord, only 3,500, how can, my lord, it is held, he was a young earning person, my lord, 3,500.
No, Syed judgment itself, lordship, 4,500 for
No.
coolie is given. He is saying,
No.
tate aise to.
600.
He to
Okay.
vegetable vendor.
Regarding
coolie.
coolie, okay.
For
My lord,
coolie. If it
reference
was,
has been
he
made.
was a labor, lordship.
My
If
lord,
he
I
was
am
a labor,
saying, my lord,
he's reading the evidence of PW1 father. There itself he is saying that he was a labor, lordship, not a vegetable vendor or something. So he was a labor, and this Syed judgment itself is referring to if it is a coolie, it should be 4,000. That's why I'm submitting, I'm agreeing to that amount, lordship, 4,500, because they are saying labor, and with that, the vegetable vendor 6,500, that is a different issue, lordship, when they are proving a occupation.
my lord, since, my lord, no income proof has been produced before the tribunal, entire matter has been left before your lordship, my lord. My lord, I have no, my lord, comment, my lord. I have given my lord, citation, my lord, your lordship kindly consider, my lord. Since, my lord, no proof has been given before tribunal, my lord, only my submit,
I'll dictate it. I think I'll enhance it to 4,500.
my lord,
Calculation will be required. I'll make the calculation.
my submission, my lord, 5,000 may be awarded. My lord, my submission, my lord.
It's not
Not 6,000.
Okay, we give out of our pocket and all that.
4,500, 5,000, my lord, lordship kindly calculate.
Not like
My lord,
that.
in respect of other heads, I have no objection at all, my lord.
See, I
He is the only son, my lord.
No, you cannot place that submission. I'm relying on your judgment.
Yes.
I'll not go to
My
vegetable
lord,
vendor, but
actually,
to
my lord,
coolie I'll go.
I am relying,
Yes.
my lord, on vegetable vendor, my lord.
No,
Some
but
reference
no,
has been given.
Vendor, you have
Your lordship-
vegetable vendor has a good income, that much I know.
Yes.
My lord, your lordship
He will not
kindly-
be earning 6,500.
He will be earning
much
more.
more.
Yes, yes.
Kindly take, my lord, 5,000.
Bahut dam boss.
Only son, my lord. And, my lord, there is none, my lord, to look after their parents, my lord.
No. See, you place your judgment then. Place another judgment. I'm relying on your judgment. I don't have any authority before me. Whatever you are submitting, whatever you are producing, I'm relying on those documents. Where is the calculation in this judgment?
Lordship, page 14.
Loss of dependency given to whom? Both the parents?
No, my lord.
No,
only
to
mother.
mother.
Mother. Okay. Should I give you one more day? You can bring the magma also. If it, you can contradict Sala Verma's decision, then both the parents will get the, I have forgotten the judgment actually.
1520. Lordship, I'm just
Sushila Devi, I think. There is one Sushila judgment for bail. And there's one Sushila for MSc. So which one I'm referring to, I cannot
My lord,
recall.
5, 6.
my lord, this judgment-
65. Lordship, the in the A amount, 65,000 has been given. I'm just showing that these are wrong, but Lordship will not deduct that because we have not filed any appeal.
Hmm.
I'm just showing the already something is 65,000 is given.
My
And
lord.
we add the conventional head Lordship, 15,000, 10,000, 15,000 and 25,000. 60, it comes to 65,000.
My lord, paragraph 23, lordship kindly for a moment, lordship kindly see, my lord, regarding my lord monthly income, my lord. Para 23, my lord.
Para 23 of your
So,
appeal.
my lord, no, my lord, judgment, my lord, Soyad Sadiq, my lord. May I read, my lord?
Yeah.
Further,
Yes,
the
sir.
appellant claimant has claimed that he has been earning as 5,000 per month by working a cleaner of a lorry. The tribunal assessed his monthly income 3,000. The High Court considered that the age of the professional cleaner assessed in income 3,500. However, based on a Karnataka statement with whether
Cleaner.
Like
What
here
are
in
you
this,
saying? Cleaner in railways, they are getting 45,000 per month.
my lord, they are my lord daily.
That was, that too in the year 2005 or 6.
You are
Cleaner
also-
in oil, they used to get 45,000. Here they are getting 9,000.
Now, here in this case, no, he's not, my lord, government, not government employment. It's a, my lord, daily wager, my lord.
I'm saying, that's what I'm saying. 9,000 this daily wages are getting here.
Here,
At
my lord,
present.
monthly income has been held 5,000.
Cleaner gets much high income. In oil, oil, long time back, in the year 2004, they used to earn 45,000. In railways, they used to earn 15,000. I'm talking about when I was working as a magistrate. Because they used to give me bail bonds for through salary slip. So that was their income then,
You
long
lost
time
it.
back.
No, because that is central government.
Employee.
They are central government employee, and oil has their own income criteria.
Big
So,
boy. And then railways 15,000.
that is central.
Cleaner's income is high. I'm sorry, I'll go to paragraph 8 only.
My lord.
Cleaner, you see,
face to face होगा अपना वही नहीं रुकिए
our learned counsel, Mr.
A Manaf.
M.
A Manaf.
A. Manaf, for the appellants, Premnath Moni and Mrs. Nori Sangma, who have filed this application. Premnath, no, the Premit Momin. Premit Momin and Mrs. Nori Sangma, who have filed this appeal, as they are aggrieved by the judgment and order dated 8/5, judgment and award dated 8/5/2019, in connection with MSc case number 41 of 2017. The appellants are aggrieved by the quantum of compensation which was apportioned, which was assessed at rupees 5,64,800 rupees. Full stop. Hart Miss R.D. Chaudhary, learned counsel for R.D. Muzumdar, learned counsel for the respondent number 1, Oriental Insurance Company Limited. Full stop. The appellants are the parents of the deceased, Witter Sangma, who met with an accident on 23/12/2016. Full stop. At about 8:30 a.m., Witter was chatting with his two friends beside a Vespa scooter parked on the side of 51 NA National Highway. Full stop. At that time, a speeding vehicle of Winger STD model bearing registration number ML 13-3310 in a rash and negligent manner hit them, and Witter, along with his friend, sustained fatal injuries. Full stop. The people nearby gathered at the spot and brought Witter Sangma to Mesel Khua PHC, but unfortunately he succumbed to his injuries. Full stop. An FIR regarding this incident was lodged by Bargrish Sangma, BARGRISH, Bargrish Sangma, which was registered as Krishnai, KRISHNAI, PS case number 1/2017 and GR case number 1/2017 under section 279/307A of the Indian
304.
Penal Code within bracket IPC for short bracket closed.
304.
304A.
Lordship says 7.
Huh?
Lordship says 7.
Oh, I heard 7.
Yes.
The parents, the appellants, filed the MSC case number 41 of 2017, where the Oriental Insurance Company was arrayed as opposite party number 1, and the owner of the vehicle as well as the driver were arrayed as opposite party number 2 and 3. Full stop. Driver did not contest the case? Did the driver contest the case?
No, no, no. They file only, they filed owner and driver, they filed only WS.
Okay.
Thereafter, nothing.
The opposite party number 1 contested the proceeding and filed written statement denying all the averments made in averments in the claim petition. Full stop. They have contended that the claimants are paid for excessive and excessive compensation. They have questioned the age and occupation of the deceased. they have also questioned the insurance policy, the validity of the insurance policy, as well as the driving license and other permits and so on and so forth. Full stop.
So P3 did not appear, Lordship. Driver did not.
Did not appear.
No, he was ex parte and do file the written statement.
The opposite party number 3, Muhammad Sahidul alias Sadiqul Islam, the driver of the vehicle number 3310 did not appear and contest the proceeding, whereas the opposite party number 2, Moinul Haq, contested the proceeding and filed his and submitted his written statement. Was it? Submitted his written statement admitting that he is the registered owner of the offending vehicle ML 133310. First off, he has prayed for exoneration as his vehicle was duly insured by policy number 322-390-31/2017/26, 36, which was valid up to 10/8/2017. And this implies that the policy was valid at the time of the accident, which occurred on 23/12/2016. It was next prayer after the claimants adduced the evidence of one witness. Adduced the evidence of one witness and proved certain documents. Full stop. After scrutinizing the evidence, after scrutinizing the oral as well as documentary evidence, it was held by the tribunal that the vehicle bearing registration number ML 133310, ML-13-3310 was the offending vehicle, and the driver of the vehicle was responsible for the accident, which resulted in the death of Witter Sangma, WITTER, Witter Sangma. The insurance company on the submissions of the insurance company and the claimants at this appellate stage, the core issue narrows down to the income of the, I'll take only one issue here.
Yes.
Narrows down to the income of the deceased. The learned counsel for the claimants stroke appellants laid stress in his argument that the evidence of PW1 clearly reveals that the monthly income of the deceased Lydia. was rupees 15,000, full stop. He has categorically stated in his evidence in chief on affidavit that his son Vita Sangma was 22 years of age and he used to earn rupees 15,000 per month, including commission, etc. as he was working as an employee under the within inverted commas trust, TRUST Trust Plastic Industry in Chennai, inverted commas closed, during his lifetime, full stop. The evidence and claim petition লিখি দিব নালাগে claim petition. The other issues are not discussed in this case, as the issue which centers around in a narrow compass is relating to the income submitted by the claimants through the claim petition, income of the income submitted, income of the deceased, which has been submitted by the submitted by the deceased through the claim petition as well as through the evidence in chief. Full stop. You have not disputed in the cross-examination relating to the income.
No, Lordship, it is not a question of it. The thing is, as per even Pranay Sethi or Sarla Verma, they have to prove the income. But they have not given any document that he was employed or as per these judgments itself, Apex court has said that they have to only a few things in a death case, only a few things are to be proved. So they fail to prove. If we put a question, then we put ourselves in that difficult position to come out of that. If we put a question, Lordship, in cross-examination, it is important that what we ask and what we should not
Very
ask.
important. Yes.
We should not ask. So when they did not prove, it is not necessary for us to put ourselves in that. That is why.
Although my lord, income certificate was not my lord given or income was not proved, reasonable should be my lord made clear, my lord. Reasonable compensation should be made, my lord. Otherwise, my lord, as per Sarla Verma and other judgment also stated, my lord. My lord, although there is no proof, my lord, reasonable justification should be, my lord, provided.
No, you cannot just say submit orally. If you have documents, if you have authority, you
My lord,
submit.
I am admitting, my lord, document has not been submitted.
So no point.
He is a daily laborer, my lord, or
No point arguing. I'm just let me finish the dictation. Then let me ponder over after finishing the dictation. It is not necessary to get into it. It is also pertinent to mention that it is not necessary to get into details of the other evidence, as the insurance company has not disputed the factum of the accident and the liability of the insurance company to pay the compensation. The insurance company has also not disputed that the vehicle number 3310 is the offending vehicle. The argument of the insurance company is that the claimants have failed to prove the income of the deceased through proper documents, full stop. The deceased was an employee. It is submitted by their it is submitted by the learned counsel for the insurer that the deceased was an employee in a company, and he ought to have proved his income through proper documentary evidence. Full stop. It was incumbent on the deceased. It was incumbent on the claimants to prove the income of the deceased through proper documentary evidence, and the claimant has failed, to prove the same. Full stop. It is admitted by the learned counsel for the appellants that no income certificate was produced, but the claimant was in fact earning rupees 15,000 per month. First off, he has relied on a decision of the Supreme Court in Syed Sadiq versus United Insurance Company Limited, reported in 2014 bracket of it, to SCC 735, wherein it has been held that para 8 and 9. I'll take para 8 and 9 because you are relying on para 8 also. Para 8 and 9. I have also scrutinized the evidence of the appellant, Premit Momin, who has stated that his son was earning rupees 15,000 per month. Full stop. He has also exhibited Exhibit 1, which is the FIR of Krishna PS case number 1/17, Exhibit 2, which is these are certified copies, no?
Madam.
Which is the charge sheet
document, madam.
of the same case, Exhibit 3 and 4, which are the seizure lists, Exhibit 5 and 6 are the MVI reports, and Exhibit 7, the PM report. Full stop. He has exhibited several documents, but he has failed to exhibit any document to substantiate that his son was earning rupees 15,000 per month.
And I submitted that occupation also, that he was working.
That
If-
I have already
Yes,
dictated.
Okay.
The tribunal had assessed as there were no income, as there was no proof of income of the deceased, the tribunal had assessed the income of the deceased to be had assessed that it would be justifiable. The tribunal had held that tribunal had observed that it would be justifiable to assess the income of the deceased at rupees 3,000 per month.
3,500.
3,500 per month, despite the fact that no convincing evidence was adduced by the claimants to prove the income of the deceased. Reverting back to this case, it is held that indeed going by the present state of economy and the rising prices and the inflation, the income of any laborer working in any industry, be it trust plastic industry, will be well above rupees 3,500 per month, full stop. Thereby, in the light of the decision of the Supreme Court in Syed Sadiq, it is held that the income of the deceased was rupees 4,500 per month. In view of the foregoing discussions, it is thereby held that the loss of dependency that amounts to rupees, it will be
Rupees, Lordship. In total, it will be 6,42,600. That will be in earlier given was 4,99,800. The increase will be of rupees 1,42,800.
800.
Yes.
You have calculated it.
Yes, he can also calculate it, Lordship. It will be better if he also calculates.
Not calculate.
Hmm.
My lord, that will
Where
be
did you
the
calculate it?
Huh.
Etu likhason 6 lakhs.
6,42,600.
That
That
next line likhason plus interest.
Plus in.
You have added interest also?
No. This is just the
Like
amount.
interest na lage.
Interest to the other.
Hmm.
This is just
Now
the
I'll also
amount. It
calculate
is
because I'll deduct 1.5 and then I'll take the multiplier 17.
yes.
Or not 1.5, I'll deduct 50%
50%.
and then I'll take the multiplier.
Yes, because Lordship 4,500.
Only for the sake of pronouncement, I am just saying it.
Yes.
So it will be total rupees 6,50,000.
No, with that Lordship, 65,000 will be added already given because we have not filed the conventional amount, Lordship. So total will come to 7,600. The 65,000 down.
Future prospects also? All
Future prospect added in that 6,42,000.
okay.
Because Lordship, if 4,500, then 50% will be 2,250. Then 40% of that will be 900 rupees. That comes to 3,150 into 12 into 17. So that amount is, dependency amount is 6,42,600.
Let's make it to 5,000 then. It's very less.
very less, my lord. That's why.
Okay, Lordship.
We'll make it to 5,000.
Okay.
What will if it
The
is
calculation.
It's very less. Thank you for calculating because I could assess that it's too less.
Okay. Apni karo ka because
You are very correct.
nahi
5 lakh, it will be 2,500 into 12 into 17. I think so.
No, also 40%.
40%,
40% future prospect. 3,000 to the future prospect.
1,000.
40%.
এক মিনিট। ও 2,000 মই আধা কৰি লৈছো যে নহয় মই অলৰেডি আধা কৰিছো তো 1,000
Just to pronounce it, otherwise I'll go and I'll inside and I'll do the calculation.
I'm just calculating actually. 500 into 12 into 17. 7,14,000 and that 65,000. 7. Lordship may calculate it. My calculation is coming to 7,79,000.
Yes.
And we have already deposited that judgmental amount. Only we have to give the
Rest amount along with the interest.
along with the interest.
Okay.
No, এই 5,000 2,500 হল হয় না আৰু হেইটোত 1,000 হল ফিউচাৰ প্ৰসপেক্ট 3,500 হল if simple 3,500 into 12 into 17 into 12 into 17 7,14,000 plus 65,000 is a conventional this
So it will be 7,79,000.
79,000 but he can make the calculation.
Then you'll get the interest, it will come to 8 lakhs.
Interest, my lord, from the date of filing
Yeah,
till realization.
You will get the date of
No, that will be more than that because the case was filed long time back.
Along with interest will
17. So 9 years interest.
Then in view of the following discussions, the
বহুতখিনি বাঢ়িল
the judgment and award dated 8/5/2019 is modified and the insurance company is directed to pay rupees ... with interest of, what was the last interest? 6%?
6%.
6% from the date of filing till the
But on future prospect, there will not be any interest.
Why?
Because that our High Court judgment is there.
No, here it has not been stated, my lord.
No, on future prospect, there won't be interest,
Huh.
but there will be interest on this in parentheses case, after every 3 years, there will be interest on.
No, that 10% increase, okay, but
10
in future
10%
prospect,
increase.
the future
No,
prospect,
future prospect, there is
no interest, yes.
It will very bearing interest on future prospect will লিখি থৈ দিয়ক।
নহলে পাহৰা যাব।
Bearing interest on future prospect. Date of filing till realization bearing future prospect. Including the 10% increase after every 3 years in the
Conventional heads.
conventional heads. Bas.
Hello, please touch.
You will dispose of it. Send back the original records from to the tribunal. Record লাগিব। এইটো হেৰি তেখেতক দি দিবা।
My lord, the insurance company will deposit the amount before tribunal.
You want it in that?
My lord, maybe, my lord,
To be deposited in the tribunal লিখি দিবা। Before
Can
the
I take
tribunal,
back the
Palpa.
pronoiety judgment? Because it is.
Yeah,
not
no,
mentioned.
I have not referred to. Let
Ah.
me, I may need some help.
Oh, then okay, no issue. Since lordship did not
My
refer,
lord,
then I thought.
Yeah.
time
I'll give it
limit.
back to you.
No issue.
In the evening, you'll be there in the evening.
My lord, a time limit may be given within this time, my lord, they will deposit, my lord.
6 weeks,
Six
weeks.
weeks,
my
begin deposit will be delivered within the 6 weeks from the date of this order. It will be made.
Yes.
Okay, it
God
will
bless.
come
I
up,
love
it will get uploaded within 5 days.
My lord.
Because now we have 5 days period window to
Window.
upload. But it will be within 5 days,
Okay.
not after beyond 5
My-
days.
Hello, please.
I love bless.
Maria.
Please, Your Lordship.
Yes.
Lordship, this matter was referred to mediation on the last occasion.
Mm.
However, I could not find any office note with regard to that.
Mediation.
Yes.
I think, according matters referred to the High Court meeting on 5th of May.
Acha.
Item 16.
I'm for the respondent.
Yeah,
so,
but the appellant is not present.
yes.
How can you submit without the appellant? Appellant is not represented today. Learned Counsel Mr.
Arkivat,
R.K. Batra is present for the insurance company.
my lord, respondent one.
Comma respondent number 1. List after 2 weeks for hearing positively without fail.
Obliged.
Item 17.
I think 17 some lordship technical issue on first week of May. First week of
Lordship, date may be fixed, Lordship,
May.
because here.
I have bring the file lordship, other that file is lordship different cases.
Railway case.
Railway,
Learned Counsel Mr. K. Gogoi is present for the railways.
lordship.
And Learned Counsel Ms. M. Sharma is present for the respondent. Full stop. The Learned Counsel for the appellant has prayed for adjournment. List this matter on 7th of May. Okay.
Lordship, lordship.
Item 18.
Time for the claimant, lordship. My learned friend, my lord, is the appellant, lordship.
উনি start করার কারণে মই ভাবিলো আপুনি
নহয়, আপনি
Lordship, I'll read the judgment first.
Hmm.
My main grounds are, Lordship, actually not against the claimants here. We are saying that
Pay and recovery.
pay and recover.
Okay,
So I need,
that is the main point. We'll narrow down to the point.
yes,
Yeah.
those are the main point.
Mm.
And on quantum, we have, and Lordship, on quantum, there is one issue. The case was filed under section 166 and that was replaced by 163.
Mm.
So
that
the
is also newly amended.
newly amended that 5 lakh.
দুখন হেৰি টো দিয়া পুৰণাখন আৰু নতুন MBA
Judgment was passed in 29th March 23 and the amendment
29?
29/3/2023
23. That amended act was already in
already
force.
there. So
on
5 lakh.
quantum relating to 2166 and 163.
Yes, 163A. It was converted to that
Mm.
maximum. So maximum compensation
166
and 160. It was prayed that the provision of the case under section will be replaced by section 160. They prayed. Claimants prayed that it be replaced by. So 163A, the maximum compensation is according to 5 lakh.
5 lakhs. Yeah.
So that will be the cap. So on quantum, that is the
163A, isn't it?
163A.
It will be 5 lakhs.
Now
on
it
that.
is 164. The section now has changed to
Again
164.
164. So on that it will be 5 lakhs.
5 lakhs. That is the cap.
Mm.
And though we have mentioned about interest and all those things, Lordship, if the pay and recovery comes, we do not have to. We do not have to go into that. That Lordship, we adduced evidence in the case, but the court rejected it, saying, I'll read the judgment so that Lordship will come to know. DW to be eyewitness of the accident. DW is not, the investigator cannot be an eyewitness to the accident, Lordship. So
DW2.
DW.
Court has held.
Court has held.
Maybe I think DW1 is the eyewitness. Maybe it was typographical error.
No, the court expected that the insurance company is giving a first-hand.
No, no court will expect.
I'll read then Lordship, it will be clear, because what we are saying is that the vehicle
How
was
can a company be a
eyewitness. Yes, Lordship.
No
The
court
court
will
has,
actually, I think there may be a typographical error.
maybe, Lordship, maybe. Lordship, should I start or Lordship? Yes, come. So we can start at 2, no issue with that.
Yeah, we can start at 2, or you can read.
Okay.
If you want, you can. How long will it take to complete reading the judgment?
Oh, Lordship, it won't be in 1 minute. He is already here.
How long is the judgment? How many pages?
13 pages. 13, but some I do not.
Very short judgment.
Very
You can
short.
read it.
Okay.
You'll read from the discussions only. You won't read the entire story. You want to read the entire story?
Yes, Lordship. No, it won't be necessary. We can go to the issues itself.
Yes.
We can start
Issues,
with the
yes.
issue. The
You can
issue
read the issues.
Yes. The
Then
issues
we
casted.
will break.
Okay. 11, page number 11 of my memo of appeal, Lordship.
Page number 11 of
Memo of appeal, Lordship. That is judgment page, internal page 3, Lordship.
Yes, page number 11.
Yes. The issues casted, whether the claim petition is maintainable, whether the accident occurred due to rash and negligent driving of the driver of vehicle number so-and-so, whether the claimant is entitled for compensation, and if so, what reliefs the claimant is entitled to what amount the claimant is entitled to, and who will be liable to pay the amount. Claimant Rupa Bora examined 2 witnesses, including her husband and eyewitness. Besides the oral testimony, PW1 exhibited a number of documents in support of the claim. The contesting opposite party adduced evidence of Mohim Bhuya and Nitumani Chaudhary as DW1 and DW2 to rebut the case of the claimant. Decision, discussion, reason thereof. I have heard arguments of learned counsel for the claimant and the insurance company. I have studied the evidence on record for purpose of clarity. I would like to proceed issue-wise. Issue number 1. Claimant impleaded the owner, driver, and the insurer of the offending vehicle as party to the suit. It is also noted that the claimant specifically asserted that the accident occurred due to rash and negligent driving of driver of Tata HYVA, which thus ingredients of Section 166 MB Act stands fulfilled. I may point out that the burden is always on the contesting opposite party to prove that the tribunal does not have the authority or jurisdiction to take up a claim case. In the case at hand, nothing credible has been shown that would indicate that the cognizance is either expressly or impliedly barred. In any view of the matter, therefore, the issue on maintainability is decided in favor of the claimant. Issue number 2. The question to be now decided is whether driver of the Tata HYVA was rash or negligent. The claimant examined as PW2 Deepak Bora, alias Dina Bora, as an eyewitness to prove rash and negligent driving. Deepak Bora, alias Dina Bora, PW2, averred that on the day of accident, he, along with his deceased son, was working as supervisor in Creative Consultant and Builder, a private firm, under Bharatiya Infra Project Limited, Thingnong, Manipur. It is testified that on 7/4/2016 at about 11:30 a.m., his son was busy working on the computer recording the data of the materials carried by the vehicle number so and so. At that time, suddenly the backside dala of the said vehicle fell down due to the driver suddenly moving the vehicle backward, and as a result his son sustained grievous injuries which ultimately led to his death at Silchar Medical College and Hospital. The insurance company cross-examined this witness. It comes out that the presence of PW in the place of occurrence is natural, in as much as it is not in dispute that PW2 was working in the same firm at the time of accident. Thus, the evidence of PW2 as regards the manner of accident appears to be credible. To fortify the assertion of rash and negligent driving by the driver of truck, PW1 has brought to my notice that the police case was registered by Nungha PS case number 15416 of 16 against the driver, which culminated in a police report while final report number so and so dated 12/2/2019. A careful reading of the final report goes to show that upon investigation, it is concluded that OP number 2 was driving the truck bearing number so and so, and that it hit Palash Bora, leading to his death. The police is of opinion that accident occurred due to brake failure, mechanical defect. Lordship will mark this part because that is why they have in fact changed that. 166, the rash and negligence has to be proved, but here the driver's rash and negligence was not there because of brake fail, and that's why they converted. However, such defense has no place in a case governed by law of tort. It need to be placed on record that vehicles on road can cause major damage, including loss of precious life. Therefore, it is expected of the owners of vehicle to keep the vehicle roadworthy. In the case at hand, it is transparent from the police report that the owner had not kept the vehicle in a manner he was expected to, and that is sufficient negligence for purpose of fastening civil liability. In any view of the matter, the claimant has been able to create a preponderance of probability in his favor, and hence issue number 2 is decided in affirmative. Issue number 3 and 4, the law with respect to the grant of compensation in that case is well settled. The criteria which are to be taken into consideration for assessing compensation in the case of death are the age of the deceased at the time of death, the number of dependents left behind by the deceased, and the income of deceased at the time of his death. Reliance placed upon a 3-judge bench of Supreme Court in United India Insurance versus Satinder Kaur, 2021 11 SCC 780. Age of deceased. Deceased was 18 to 19 years old as per the postmortem report. However, ideally some credible document like Aadhaar card, voter ID card, etc. ought to have been proved. Since these documents have not been exhibited and since age has a direct correlation with the multiplier, I deem it fit to take a conservative view of the matter and hold that the age of the deceased would be computed in the range of 26 to 30 years, and thereby the multiplier would be reduced by 1. Income. A bare reading of the evidence of PW1 and 2 goes to show that the deceased was working in a private firm at Manipur. On this point, there is little cross-examination. However, his income has not been proved. Therefore, this tribunal has treated the deceased as an unskilled worker employed in a private firm. To determine the income of such person, this tribunal rely on the principle laid down by 3 judge bench of Honorable Supreme Court in Christie versus Oriental Insurance reported, the apex court observed that the very least the minimum wage applicable to state where the deceased was residing over ought to have been taken as notional income. Therefore, I have looked into the notification number so and so issued Principal Secretary of Government of Assam Labor Department. As per notification, the minimum wage per month of an unskilled labor worker, including the variable dearness allowance, has been fixed at 8946.30. However, the road traffic accident took place in 2016 and the rate applicable at that time is not available. In absence of notification relevant to that period and having regard to the present rate, which is almost 9,000, this tribunal deems it fit to hold that the monthly income of the unskilled worker working in a private firm in 2016 would be around 7,500. Deduction of income. Actually, the deceased died while he was working itself. He was making the computer entry. So that way, some kind of work was proved in this particular case. In case of bachelor, 50% of his income should be deducted towards his personal and living expenses. In the instant case, the deceased was a bachelor. Hence, 50% of the income of the deceased has to be deducted from his annual income for the purpose of computing the compensation which is to be received by the claimant, the multiplier. I may now point out that deviating from the schedule, Honorable Supreme Court laid down the multiplier system in Sarla Verma versus DTC 2009-6 SSC 121 and concluded as under. We therefore hold that the multiplier to be used should be as mentioned in column 4 of the table above, prepared by applying Sushma Thomas, Dilak Chand and Charlie, which starts with an operative multiplier of 18.
It's okay. It's okay. I have read
Yes, this is just in that view of the matter, for the age range of 26 to 30, multiplier is 17. Annual income rupees 7,500 multiplied by 12, 90,000, deduction half 45, loss of annual dependency 40.
Actually, there's a new judgment. I have forgotten. He also didn't submit in the earlier case. I have forgotten. There's a new judgment. I don't know the strength of bench. I do not know. But you know, it is the insurance company who has to produce the latest minimum wages.
But
of the
Lordship,
area.
at that point of time, in this judgment also it is mentioned, at that point of time,
It was
is
less.
not there. And moreover, in the earlier
This
case,
judgment is of 2025 last year. And this
I also know that
this judgment is 2021.
No, the court has said that the judgment was there, but the person was working 2016. So that is, it is mentioned in paragraph 20, Lordship.
And here in this case, it was a judgment of 2017 or 18.
So the court has mentioned that the absence of notification relevant to that period. It is not there.
It is not there.
Because now those notifications are coming of the government is trying to
minimum wages.
Minimum wages. So naturally in those cases or in this case the court is not wrong because the
But
court
you
has,
know that the insurance company has to.
yes, I know the judgment.
Yeah.
I do not remember it right
I
now.
also not remember.
Those we are doing in the new cases that we are mentioning it.
Yes.
In the new cases we are mentioning
Yeah,
it.
they are bringing. All
Huh.
the insurance companies are bringing.
Because that way it helps the insurance company also. Otherwise, some courts they hold ki 9,000 or 15,000, 12,000. So that
becomes very high.
Very high. Because Lordship saw in the other case 1,000 difference also makes a lot of difference
yes.
in the ultimate
Yes,
calculation.
true enough.
So this is the calculation, Lordship. I don't think I have to read this.
So we'll come back and we'll.
Yes, because after that, Lordship, from para 28, when our discussion of our evidence is there, I'll start.
So after break, we will come back and then you can submit your concluding part relating to the PS. Another interlocutory application is pending for disbursement of 50% of the compensation, which has been vigorously resisted by the insurance company, this case may be taken up for hearing positively on a short date due to on the next date on a short date, no? within a short time, immediately লিখি দিয়া, as expeditiously as possible, within a short time নালাগে, as expeditiously as possible. Full stop, list this matter as top of the list on 7th May. So hearing top of the list.
Only issue will pay and recover.
Hmm?
Pay and recover is the issue.
That's why I was ready to do that also, but naturally Lordship has done so many. His
today-
case also I'll do. We need just that order. In this case also, though we are doing so much of hearing,
Hmm.
I do not have anything with the claimant. Only thing I need a direction from Lordship that we can recover it from the owner of the vehicle. That is the only issue. And our High Court judgment, Supreme Court judgment, I'll show.
So this will come on 7th of May,
Might be.
positively without
Might be.
top of the list for you.
In supplementary list of
Like-
as per 33
Hmm.
and for the respondent.
Hmm.
So finally a date may be fixed.
Yeah.
Because the appellate counsel, Mr. K. Gogoi has already fixed one matter on 7th of May, item 17. So this matter may also be fixed on 7th of May.
Due to এইটো আগতো লিখি দিবাচোন, due to paucity of time, list this matter on top of the list আগতো লিখি দিবা. Due to paucity of time, list this matter on when do you want? 7 PM, নহব. Already 3 matters are already fixed. 12 years.
Okay. Which is, item number 32, let's say, please fix a date. 32. Next thing.
For hearing, no? Due to paucity of time, list this matter positively on 14th of May. Do you see this matter on 14th of May? লিখি দিয়া, positively না?
Page 17, Lordship, of my memo of appeal, Lordship, I was reading.
Yes.
Paragraph 28. Whether insurance company is liable to pay the compensation or not. As per the claim petition and accident information report, the vehicle number so-and-so was insured with Oriental Insurance Company Limited by policy number so-and-so, which was valid up to 1/11/2016. The accident occurred on 7/4/2016 and was thus within the validity period of policy, driving license. The insurance company, this is our part, Lordship. Insurance company examined 2 witnesses to try and prove that OP number 2 was not competent to drive the offending truck. It has been averred by Mahim Bhuya, DW1, and Nitumani Chaudhary, DW2, that the driving license of Mohimuddin Bor Bhuya was only to drive LMV and that he was not competent to drive the offending truck. It has been testified by these DWs that the laden weight after goods are loaded of the truck was 10,000 kg. In cross-examination, DW1 admitted that he does not know whether the vehicle was loaded or unloaded at the time of accident. However, as per Exhibit B exhibited by DW1, the unladen weight was only 6,200 kg. It is settled law that the vehicle below 7,500 kg can be driven by a person holding an LMV license. As OP number 2 was driving a vehicle whose unladen weight was only 6,200 kg, DW1 admitted that he has no knowledge as to whether the vehicle was loaded or not. In that view of the matter, I hold that OP number 2 was competent to drive the offending vehicle. In the result, the owner has not committed any breach of policy condition. What follows is that the insurance company is liable to pay the compensation. So after that, now Lordship, I'll show Lordship the final report was exhibited by the claimant themselves, in which it is mentioned. Actually, I couldn't go through the record. I had a mediation case in between at one. Otherwise, I would have shown the page number, Lordship, in the trial court. In the final report, Lordship, while Tata Tripper bearing registration
You
number,
have a copy of the final report
it should be there in the year because it was
in the trial court record.
court has discussed.
Trial court record.
Yes, it must be there, Lordship, because court has discussed at paragraph 15.
Final report.
But I could not flag mark final report. That is
What is the
final
exhibit? What is the
exhibit Roman 12 in bracket 1.
Roman 12, no? Yes. We have the final report. please.
Yes. Lordship will come to the third paragraph. And from top, 1, 2, 3, 4, 5, 6, sixth line, Lordship.
Yes.
While Tata Tripper bearing registration number so and so, loaded with construction material, came to the work site on the head of Polas Bora. It was laden at that time, Lordship. But the court came to a finding that it was, how the DW will know whether it was laden or, that is why I said, Lordship, the eyewitness part. The court has said that DW could not say whether it was laden or unladen. It was laden at that point of time, and so there was violation of policy.
Which paragraph? 3.
Paragraph 3, Lordship. Paragraph 3, that starts from during the course of investigation, examine the complainant whose statement corroborated with the OE of the case.
Yes.
Their Lordship will come to 1, 2, 3, 4, 5, 6 line, Lordship. It is reported that the unfortunate incident had occurred while Tata Tripper bearing registration number so and so, loaded with construction material, came to the, because that is the case, Lordship. It was laden. And when the bonnet was open, it hit him, the deceased, Lordship. So, huh? And then, Lordship, again in 1, 2, 3, 4, 5, 6 paragraph, Lordship, he stated that he was coming from worksite carrying construction material.
Paragraph 6.
6 of that same final report, Lordship.
He stated that where?
The paragraph starts with, it further course of investigation,
Yes,
the
yes.
accused driver of the vehicle number, so namely Sri so and so, was arrested and tactfully interrogated in connection with this case. He denied to have driven the vehicle rash and negligently. He said he was coming from worksite carrying construction material. So where the vehicle was laden, it was before the tribunal that, and we proved the policy that also the driving license of the driver, Lordship. So my humble submission in this case, Lordship, we should be directed to give the amount to the claimant, but we have a right to recover it from the owner of the vehicle. Because they violated the policy condition, Lordship, by allowing the driver who had a LMB vehicle, and they are not some individual, Lordship.
So
They are collective consultant
this
and
pay and recovery, that proceeding will be before the tribunal.
tribunal, yes, Lordship.
So here I can only pass an order directing
us to deposit the amount within a 6 weeks or something, and then the tribunal will proceed with the as per Nanjappan. Our High Court judgment, if Lordship needs, I can.
Yes.
Nanjappan judgment I am giving.
Yeah.
And our High Court other.
Was
In that proceeding again, I think the evidence will be taken.
No.
No,
That
only-
is just recovery.
Only just recovery.
Only recovery. That's why I'm giving Nanjappan. I will take from if it is. Our High Court, one judge, I have so many judgment, but I'm not burdening Lordship with
One judgment will be
one
enough.
from Supreme Court I'm giving, and one from our High Court, and also Shamanna I can give in.
Which paragraph? Nanjappan?
Nanjappan Lordship, paragraph 8. Their Lordship, how it is to be recovered. Lordship has already said that, but I think Lordship
There will be a
knows it.
proceeding, yeah.
Yes, Lordship knows it. Paragraph 8. Down below. Therefore, it starts from therefore. How it is to be recovered. And Lordship, our High Court judgment, MSC Appeal 132/2020, we have given. That is, Lordship, there also Nanjappan was followed. And Lordship, there, paragraph 11.
Okay. You can read this paragraph, paragraph 11.
The appellant insurance company shall be at liberty to recover the awarded amount from the owner in due course. Before releasing the amount, the learned tribunal shall issue a notice to the insured owner of the vehicle who shall be required to furnish security for the entire amount that the insurer will pay to claimants, in accordance with the law laid down in Oriental Insurance Company versus Nanjappan Supra. The offending vehicle shall be attached as part of security. If necessary, the executing court shall take assistance from the Regional Transport Authority. The executing court shall pass appropriate orders in accordance with law regarding the manner in which the insured owner of the vehicle shall make payment to the insurer. Lordship, moreover, what is important, this is not a owner who is just an individual. It is a company, Lordship. So they have money. They have, after receiving the notice, in our appeal also they received notice, they did not appear, and they filed a IA. In that they had taken step. In that also they received the notice, they did not appear. So they know that there is willful negligence was there in their part. They know it, and it is a construction company, Lordship, creative consultant and builders.
This is the first time I've heard of such an accident. That the truck, bonnet of the truck is opened and it falls.
Maybe the construction material was, in fact, ration negligence. If we go by that, full ration negligence is not there of the driver. But I'm not going into that because someone has died, Lordship. I'm not going to argue on that point, Minubi Mehta cases and all. Since someone has died, so let them have. And moreover, about the other ground, Lordship, my friend says that they had withdrawn the application of transferring it from 166 to 163A. So if that be so, then that ground won't stand if they are correct in that. They said ki there is order, they will show that order. So
They have
that
withdrawn the
on
application.
quantum we do.
So then I'll cut out that note where I have recorded it relating to converting it into, I'll cut out that part of the note.
Yes. They said, Hussaina, order Hussaina.
Malota, kindly see the order dated 39/2022 of the Tribunal, Lordship.
That knowledge I did
Yes,
not have.
Lordship.
In the LCR, no?
Lordship.
So it's not required there.
Not
Yes,
required.
yes.
I'm not pressing that.
I'll check the order.
Yes, since my learned friend did not press this.
No, because you
Ground, Lordship.
you informed me.
39/22.
Yes, Lordship, 39.
Three.
Yes,
Parties are represented, does not want to press the petition to convert the instant case under section 163A of the MB Act.
yes.
Okay. So what was the quantum awarded?
Lordship.
What,
11 lakh,
for the-
11 lakh something.
Oh. No, এখানে কিমান day submission?
11,58,000.
11 lakh 59,000, Lordship.
50.
50.
So you have anything to say regarding the company?
Lordship, no, Lordship, my Lordship expressful submission is that, Lordship, since my learned friend is agree with me to draw the Lordship 50% amount, because I have filed a IA, Lordship, for getting a Lordship to draw the fixed amount which has been submitted or deposited by the company, Lordship, before this registry, Lordship. And another is, my Lord, so far the Lordship loaded and unloaded consent of the vehicle. Lordship, one report, Lordship, that is the Lordship given by the Lordship as submitted by the Lordship DTO authority. And my Lord, additional written statement, Lordship, submitted by the Lordship DTO authority, Lordship. Lordship, DTO. Oh, investigating officer, Lordship. Lordship, perhaps it is, Lordship, in the record, Lordship. My Lord, this is the report, Lordship.
Okay, additional written statement was submitted by the
Investigator.
That
Investigator.
is from the insurance side only.
Lordship,
Yeah.
insurance site, Lordship. Lordship, my respectful submission is that, my Lord, based on this, Lordship, based on this verification report, my learned Lordship pressing before this honorable court, Lordship, regarding the vehicle was loaded.
No,
But-
not on this. On their document, I am relying on, Lordship.
My Lord,
No, she is relying on the final report.
Final report,
yes,
because
sir.
that is the police report and that is exhibited by them, and we have not objected to that.
Exhibit 12 too.
My Lord, yes, my Lord. My Lord, the vehicle, whether the vehicle was loaded or unloaded, the investigator, he himself, Lordship, deposited before the learned tribunal that he does not know whether the vehicle was loaded or unloaded.
How he will
My
know?
lord,
She-
yes,
he is
lordship.
not eyewitness. That's
He-
why I mentioned
no,
about that
lordship.
eyewitness.
He
thing.
was the investigator, lordship. Two investigators were there, lordship. They themselves, lordship, specifically lordship, made a submission before the court, and their evidence adduced before the tribunal that they do not have the knowledge whether the vehicle was loaded or unloaded. Well, since it was not ascertained by the investigator, therefore, lordship, this plea cannot be entertained, lordship, because investigator he himself, lordship, submitted the written statement, lordship. Therefore, lordship, whatever the lordship amount,
He submitted written statement. and
yes,
did he-
lordship,
No, did he adduce evidence?
yes, lordship, evidence is there, lordship. Lordship, kindly, lordship, DW1, statement of the DW1, lordship. For a moment, lordship, merit, lordship.
Yes.
Deposition of DW1. Name, lordship, Mohim Bhuya. My occupation is private investigator, Oriental Insurance Company.
Yes.
Oriental Insurance Company has entrusted me to give evidence in MSC case number so-and-so. Exhibit A is the authority letter. I have collected the RC verification report through RTI, Thambal, Manipur. The vehicle number is so-and-so, so-and-so. The laden weight of vehicle is 10,000 kg. Exhibit B is the RC verification report from DTO Thambal, Manipur. Lordship, kindly come to cross sanction.
Cannot find the DW1, no?
DW1. Side of the point.
No,
Page 240.
I can find.
Yes, and I do have my heavy subjects.
Yes, cross, yes.
Got it, Lordship?
Mm.
And the cross. I do not know whether the vehicle was loaded or unloaded at the time of accident.
OPW1. Okay.
Yes,
I
Lordship,
understand
DW1.
OPW2.
No, Lordship, DW1.
OPW2 এ হবো, opposite side. Moving there.
Yes, as it was saying. Lordship, got it?
OP লিখা আছে।
Hmm?
এটা OP তে লিখা আছে।
Yes.
It's a cross
Mm.
section, Lordship.
Mm.
I do not know whether the vehicle was loaded or unloaded at the time of incident. The laden capacity was a so-and-so kg. I do not know the name and signature of the person who have signed Exhibit B. It is not a fact that Exhibit B is not a genuine document. Melody himself, Lordship, adduced his evidence before the court that the vehicle was whether loaded or unloaded. It is uncertainty, Lordship. Uncertainty thing cannot be, Lordship, believed, Lordship. The investigator, he himself, Lordship, deposed his evidence before the Honorable Court, Lordship. And Lordship, DW2, Lordship. Nitumani Saudhury, Lordship.
PW2 or DW2?
DW2, Lordship, here in state, Lordship, DW2, Nitumani Saudhury.
Mm.
Lordship, I'm reading, Lordship.
Mm.
Oriental Insurance Company has entrusted me to give evidence in MSC case number so-and-so. I have verified the driving license number so-and-so, which was issued in the name of Rohimuddin Borvia. He was authorized to drive so-and-so. Exhibit C is the driving license verification report from DTO Hailakandi. Exhibit D is the insurance of the vehicle so-and-so, and policy number is so-and-so. Cross section, my lord. I do not know the name and signature of the person who have signed Exhibit C. And it is not a fact that Exhibit C is not a genuine document, Lordship. I have not collected any document from the police station. The license was valid up to 12/1/2017. Explain, however, the driver was not
You see,
authorized to
now,
drive the.
There are two questions. One is that investigation takes after the long, after a long time after the accident. But at the same time, the document which you have produced, they are relying on the document which you have produced. Without evidence, can I take into account the document which they have produced?
It is exhibited. It is
Lordship,
exhibited as
himself,
exhibit.
Lordship denied the signature, he does not know, the signature
No,
of
but
whom.
no, Madam, Lordship is asking about exhibit 12. This is exhibited by you.
Which you have exhibited, final report.
Fine.
That is not.
Final report, Lordship, when the Lordship, this is the report of the, this is the report of the police authority, but the evidence of the Lordship investigator. What is the, my lord, evidence of the investigator or Lordship? He must ascertain, Lordship, whether the vehicle was loaded or unloaded. That has to be proved to Lordship. Without a proof of the document, Lordship, how Lordship can be considered? It cannot be considered, my lord. There is settled proposition of law.
Cannot be considered.
Yes, Lordship.
Which-
You
My
have to
lord,
prove the consent.
yes, Lordship. Mere
Lordship,
submitting the
no,
document.
this was exhibited by them.
No, but you have to, even though
Yes,
exhibited by
Lordship.
them, you'll have to prove the content.
Yes.
No, Lordship, accident, they are denying the accident. Are they denying the accident?
Document itself
No.
clearly says, my lord.
No, suppose, Lordship, the case of any claimant should or any plaintiff should stand on their own foot. Suppose Lordship is discarding whatever he is mentioning, Lordship is discarding DW 1 and 2. Lordship is discarding that. But they have exhibited exhibit 12.1, Roman 12.1, which is not objected to by us. They have exhibited. Therein it is clearly mentioned. After that, where is the necessity? In fact, there was no necessity for DWs also in this particular case. Because
So why did you adduce DW2, which is
Yes,
going against?
yes,
you?
Lordship.
it is not going against us. What he is saying is that what he is saying is that RC verification report, if this is objected to them, but the court has relied on 7,500 kg based on this RC verification report. The court cannot rely on this. If they are challenging this, they are saying that it was not proved. But no one is questioning this. And Lordship, thing is here, we are not challenging anything that the claimant is entitled to. We are only saying the owner has not come. Why they are getting into this controversy? What is their interest in getting into? Lordship will dismiss our appeal. The insurance company can very well go to the apex court, but that is not the intention here. Because so much of money, 11 lakh something plus interest is.
Yes, you are not the owner. Why
he is taking up this idea? It is
You're
going
the claimant. Why?
detrimental to him.
My lord, I'm to Lordship.
For a moment, I forgot you are the claimant. I thought you are the owner.
My lord, yes, Lordship. I'm not the owner, but my lord,
Then why are you in favor of the owner?
no,
Let
Lordship,
me-
I'm not Lordship. I'm not the owner. I'm a lot.
They
are waiting for 2017.
See,
They are waiting from
What I'm
2017, Lordship. 9 years they are waiting.
this
And now
document has been not disputed by them. You have exhibited this
Yes.
document.
My lord, what I'm submitting before this honorable court. Lordship, mere submitting any document before the honorable court. Can it be, Lordship, taken into consideration until and unless, Lordship, it has been examined and approved by the author or
It has been proved by you, no?
Lordship,
Yes, they have exhibited.
Lordship, Lordship, so far the Lordship.
No, you're not required to prove like a criminal case.
No, preponderance of probability.
You have introduced the document, you have proved it.
Lordship, my
Otherwise, they cannot prove an
Lordship.
accident itself. Then to prove their accident, they have exhibited this
If you're
document.
disputing this document, you cannot prove the accident.
Yeah.
Correct.
Lordship, another thing, Lordship, that Lordship, I'm referring the Lordship report itself, Lordship, regarding the laden and unloaded vehicle, Lordship. This was the Lordship additional written statement submitted by the investigating officer. Here is also, Lordship, this was not examined and this was not approved by the authority before the honorable tribunal also.
Written statement is not exhibited document.
Lordship,
Statement has already.
report, Lordship.
Lordship,
Report
the
submitted by the
Lordship
authority,
is very
Lordship.
correct. The
I am not-
investigation of the insurance company starts only when the claim case is filed. Otherwise, there is no investigation. But the police investigation is immediately after the accident, and they have They have, that's why I mentioned.
Whether the lordship document was verified or examined before the learned tribunal or not. That is my lordship, my
It's
submission.
been proved by you.
Lordship, the verification report submitted by the authority lordship.
Which
So,
one?
Lordship additionally.
Exhibit?
No, that was not.
Additional written statement submitted by the investigative
Written-
authority.
Written statement.
Additional written
exhibited,
statement.
Lordship.
Written statement cannot be relied until and unless you give evidence.
Yes.
My lord, my prayer is that at this stage of lordship, my lord, since the lordship claimant is the only deceased boy, young boy lordship, only the claimant's son lordship who has gone to lordship. My lord, the accident took place in the year 2016 lordship. Till today, lordship, not a single penny she
That
obtained
is
lordship.
submitting lordship.
Lordship,
They are-
even lordship, the quantum awarded by the learned tribunal lordship, that is rightly passed by the learned tribunal, considering the all aspect of lordship. Therefore, to lordship, my submission before this honorable court is said that so that the my lord claimant cannot be lost at any lordship, penny lordship. This is my humble submission.
No, that's why I'm not submitting anything on quantum
And
lordship.
my and another submission is that lordship, I may be disposed of and directing the authority to disburse the amount. Lordship, I am specifically mentioned lordship in my title page. The company also lordship has already deposited a amount of lordship 5,79,000 on lordship 50% amount lordship on 12.24 lordship. Lordship, kindly see for a moment, lordship, my IA, lordship.
Lordship, if the amount is deposited with the tribunal, this amount will be returned back to the insurance
No,
company.
no, lordship.
And
No, lordship.
when I submit,
No.
I-
How it can be lordship after 10 years, lordship? Is it the law of lordship that lordship if people are getting suffering, lordship? Claimant and lordship, is there any law
when I
that
submit what is happening.
claimant will suffer lordship? Only son, my lord. My lord, it is very pathetic, lordship. My lord, she is become claimant, Rupadev lordship, becoming lordship retarded day by day, lordship. Only her son was gone to lordship.
Can I submit?
Only what these are that ground to lordship, my lord, matter is lordship will lingering. My only submission is that lordship, I may be disposed of directive authority to release the amount, lordship.
What is the conclusion of the judgment?
11 lakhs.
No, how was the insurance company directed to pay?
Pay.
And but you want to
Pay and recover.
pay and recover. You want to pass an additional order to pay and
Yes,
recover.
yes. Lordship. Because I showed lordship from their document itself, he is harping on our evidence, our written statement. Written statement is not evidence. And even if we do not give any evidence or our evidence is discarded, lordship, then also their documents, all their documents are proving the pay and recovery. Lordship, what I am submitting about pay and recovery is that lordship already said that Nanjappan judgment I have shown and other high court judgment. If lordship differs, then it has to be referred to then again larger bench, because already, and I can give some more our high court judgment. Justice Surana had also passed Anjali Kolita case that the pay and recovery is to be there, how it is to be done. That is why I'm submitting lordship. Lordship will give a time frame that within this 6 weeks or 4 weeks, whatever lordship wishes, we will be depositing it, and then they can file a petition to withdraw that from the tribunal. That is the if they are challenging the other part, that the what is to be challenged by the owner, if at all there is a challenge, then they are going to be the loser.
Who is the owner here?
No,
Lordship-
they have not appeared.
Lordship-
They have received the notices. Lordship from 2000, he's saying that 2016 they died. And 17 the case was filed, lordship. For 9 years they are not getting. 6 weeks they are going to get the amount. What is wrong with that proposition?
My lord, my learned friend can deny the statement of the investigator,
Not denying.
which was adduced before the honorable court, lordship.
I'm not denying. I'm not denying.
He is not denied.
Why should I
Lordship,
deny?
another thing, lordship, that since the appeal filed before this court, lordship, again, how the lordship claimant will go and get their money from the tribunal, lordship. My
That is the-
respectful submission, lordship,
I didn't understand you. What you were you saying?
lordship,
You were saying that the.
Deposited amount already, Lordship, insurance company has a deposited rupees 5
No,
lakh.
no, earlier to this.
No,
You
you
said-
said that how the claimant is going to get recover it from the tribunal. Get it.
My landed page that is that the. Since the my lord already money is there, Lordship. Money is here, Lordship.
No, here.
Only for observation
They will
to be
lose.
given by this honorable
If
to.
that direction is
Oh,
given, they will
yeah.
lose 50%. If
My lord,
that is the submission.
Lordship, for a moment, kindly see my lordship, my IA Lordship.
No. We'll dispose it up together.
Yes.
My respectful submission is that whatever the amount given to by the learned tribunal Lordship, that should be intact, Lordship. This is my respectful submission.
We are ready to honor that. We are
And-
ready to give that.
And my lord, a direction may be given to my authority Lordship, which is a deposited here in this court Lordship, and that may be Lordship.
Suppose this
would-
goes against you, they will appeal before the Supreme Court.
Yes.
Immediately I pass an order, they will immediately go to the Supreme Court and Supreme Court will and then pass an order for stay. Supreme Court will definitely pass an order for stay. These are the presumptions. No, not presumptions. This is the possibility. So you see, Supreme Court will pass an order for stay, you'll get only 50%. Then you, if the order goes against you, you'll have to return the 50%. How will you manage to return?
My lord,
She's.
Lord, that- no, I'm not going to. No, no,
100%.
100%, yeah. Full amount.
My lord, full amount should be given. That is my earlier occasion. I am submitting before this honorable that full amount should be given to the claimant Lordship. And where from my learned friend will collect, where from they will my lord, how they are Lordship authority to get from the owners. That is up to them, Lordship. But I am the claimant Lordship.
The tribunal. You
I am
haven't
the claimant
seen
Lordship.
the
I am
judgment
the
of
claimant
judgment.
Lordship. I am entitled to hold the amount Lordship.
No, it is for the tribunal to start that. We do not have direct anything. We'll just deposit it in tribunal and tribunal will do the thing. আমি registry একো কৰিব নালাগে sir.
You think about it.
Lordship, full amount may be Lordship directed to
That is,
release.
they are honoring it.
Lordship.
They are saying that they will pay they'll pay the amount, entire amount they will pay.
Yes, a Lordship observation may be Lordship given. Lordship.
And an order may be passed for pay and recovery. But only I have one question, and this has to be answered in convincingly. That this exhibit, I'm not getting convincing answers from both sides. This exhibit 12, whether I can consider, only if I can consider this, then I can pass this
Because
judgment.
this is the document, Lordship, on which the accident is proved. This is the document. They have proved their accident based on this document. Otherwise, there is no final report. And it was here, Lordship, they have filed under, and that's why I said I'm not arguing on that because someone has died. In the report itself, Lordship, it is FR, it is final report. Otherwise, it would have been charge sheeted if the driver had driven rash and negligently. But it was not so accidental in nature. It was not rash and negligent driving. But I'm not harping on that. But this report, Lordship, is since it is exhibited by them, they cannot now say ki no, the court has to take a different view. It is, apuni hekon deny kori ase neki apnaloke je exhibit korisil.
No, I am
Because
not.
this is-
I am not on behalf of the Lordship, owner Lordship. I am the claimant Lordship.
No, this was exhibited by you. Apuni jikon exhibit 12.
Exhibit 12, I'm talking.
Lordship, I am not talking about it.
If I'm asking, then you have to talk about.
Because my lord,
I'm asking a direct question on
My lord,
exhibit 12, you
is
have to talk about exhibit
all
12.
these things, Lordship, considered by the learned tribunal Lordship. After considering the all aspect Lordship.
No, but I am an appellate court, not I am
Yes, Lordship.
not a read court.
Therefore, Lordship, I am Lordship repeatedly submitting that Lordship, the whole amount Lordship may be given to the claimant Lordship.
No, but you see, when I'm asking you some question, you have to give me the answer. You have submitted so many times that the whole amount to be given, but I'm asking you one question, you have not answered it. Whether you are relying on exhibit 12. Yes, please.
of the,
I am asking you a direct question. I need a direct answer.
my lord, this is the police report, Lordship.
Hmm.
Lordship, my lord, with regard to the police report, I don't have anything to say, Lordship, because
Court is asking whether you are relying or not.
this is how I can really rely, Lordship. This is the report given by the police, Lordship. How can I rely, Lordship? I am relying, Lordship. I am relying, Lordship, with the only two grounds were taken. My learned friend is a death in her reply. Only two grounds. One is a lordship conversion from page 166 to 163. Another is whether the vehicle was leaded or
No.
unleaded. These were,
She's not stressing on another ground. She, otherwise,
Yes,
if you
yes, my learned
insist,
friend.
you stress on that ground,
Yeah.
that it is a final report,
yes, lordship.
then 166 won't lie in a
Lord,
final
yes,
report.
lordship. Yes,
It's not a charge sheet.
lordship.
Whether it is an accident or whether it was a rash and negligent act. Accident per se, or whether it was a rash and negligent act. See, in civil case, I cannot rely on police report.
Yes, Lord.
Even in criminal case, I cannot rely on police report. How can you rely on police report in a civil case? You tell me.
Yes,
If you're relying on Exhibit 12, that's a
Yes.
police report.
yes, Lord.
But based on that, Lordship, police report is, Form 54 is also police report.
You see, any criminal case in relating to MSCT, we are not necessary to go by the criminal
No,
case.
it is not necessary.
Yeah.
If that there is any acquittal or in that doesn't, they will get the compensation. There is no, that's why I'm not touching compensation part at all. Only the laden and unladen part, the weight of the vehicle, that is only I'm, yeah, because court has
This
given.
is a very sensitive issue, you see, sensitive point.
Because
That loaded part, you are relying on a police report.
Yes, yes.
And
Lordship, otherwise it will come as use of the vehicle.
And evidence also, Lordship, investigator or evidence also before the court clearly says he or she does not have any.
you are relying on a police report. I'll give you some time. If you can give me 1 day time, I'm giving you. If you can both the sides. You see that court has held that on the investigator's report that the vehicle was not loaded.
Yes, yes, Lordship.
No, investigator says he doesn't know it was laden or not
Yes.
laden, but the court came to a conclusion, different conclusion.
Therefore, the Lordship, therefore, the Honorable Tribunal Lordship rightly Lordship decided in favor of the claimant.
Yes.
In favor of the claimant, Lordship.
Yes.
How Lordship, if they are exhibiting
Very
this
good.
document,
But the amount that should be Lordship, that should be Lordship.
decisions made by
No, I'm giving you a short date. You convince me on that police report. Only one.
police report is, Lordship, police report is MSC cases. Otherwise, how will this our okay, I'll give that judgment, Lordship, big judgment. How the police are supposed to give a report and 150 under 158 and all that, Lordship. That judgment I can give. No issue. Because otherwise, the accident itself doesn't get proof, Lordship. Otherwise, suppose this is not there. So they will come and say the son met with an accident. Will there be a proof? No. It has to be taken into consideration. Otherwise, how the court will come to a, and moreover, Lordship, the harping on the DW that he did not see, naturally he does not know
No, you
whether
will not see. That is true.
that is why in my memo of appeal, in one ground, I have said that the court expected that the DW should, DWs to be, as well as in fact in expecting the DWs to be eyewitness to the accident, because the court has relied on the fact that the DWs said that they do not know whether it was laden or unladen. How will, after so many months of accident took place in 16, case was filed in 17.
No, you see, when I'm.
Gohar Mohammed case, Lordship. Gohar Mohammed case,
what?
I will give that, Lordship. In that, how the
22?
police report, Lordship?
No.
23.
That will not work. You see, evidence in MCT cases, evidence relating to criminal offences, that aspect has to be taken into consideration, and how, in what manner, on touchstone or preponderance of probability. of
Godavari
case
Devi, that
Uh,
is Godavari Devi.
on in how and in what manner this evidence which has been documents which has been proved,
Hmm.
whether the how it has to be proved and whether this can be taken into consideration.
Yes, yes, Godavari Devi. and
Because
Godavari
that whole
Devi.
judgment has to be upturned. That MSCT's cases whole MSCT courts whole judgment has to be upturned. So this is the main point, core question. So it has to be
I'll write down,
dealt
Lordship.
with seriously, with a
Yes,
serious
I'll-
note.
I-
We cannot just dismiss
I'll
it.
write down the question, Lordship.
Because she is insisting on a valid fact, that is pay and recovery, which can be taken into consideration from an exhibited document which has been brought by you. So how this documentary evidence can be assessed, how this documentary evidence can be assessed, how the evidence can be assessed, and what point to be taken into consideration. This is very important. You'll have to go into proof of documents, I think.
Godavari
Evidence-
Devi judgment is there, Lordship, that preponderance of probability.
Yes.
That is the
Evidence Act, you
Uh-huh.
have to go into everything.
Uh.
But we do not need to go into that proving that document and that point beyond reasonable doubt like a
Uh,
criminal case.
Yes,
So
that is what.
when will you be able to submit on this? Tomorrow, day after tomorrow? Day after tomorrow is Saturday.
That Saturday I
No.
don't come, Lordship.
Saturday, that's a holiday. Second Saturday, I believe, or third, fourth Saturday,
My lord, first week of May, lordship.
first week of May. Okay.
Lordship, either lordship, it will be 12.
We'll dispose it off together.
Yes.
No, I'll not keep
Yes.
it as
Lord.
I'll not keep it as part heard.
Yes.
If I am in a DB or somewhere else, then
Uh-huh.
somebody else will take up and dispose it off.
Yes.
12.
But if I'm there, then nothing like it.
It will be, yes.
কিমান তাৰিখে খোলা আপোনালোকৰ? ঠিক আছে, যেনেকুৱা আপোনাৰ convenient, মোৰ এখন
12, my lordship,
Okay.
12 of May.
Okay. Learned Counsel, Miss.
So since Lordship is not keeping it as part heard, so
Hmm.
other things are not necessary to be noted down,
No,
maybe.
Learned
Because
Counsel-
the new
only
court
your
will be
presence.
hearing,
Yeah.
yes, new court will be hearing
Yes,
on
yes.
the whole.
Parties are represented today. Learned Counsel Miss Hadi Mazumdar is present for the appellant, and Learned Counsel Mr.
Yes, Ali.
S. Ali is
Lord.
present for a respondent. List this matter for hearing positively or without fail on 12 May.
Highly obliged, Lordship.
If I'm here, then on that day, I'll
No
give
issue,
the order
no
and the
issue.
judgment.
No issue,
I'll dictate it in the court,
no issue.
Lordship.
so that the petitioner won't suffer like you have suggested.
Lordship.
You have
Huh.
also suggested.
Yes, Lordship.
Because 9 years he's not
So,
taking anything.
I don't know why I believe that you are more concerned about the owner than the claimants.
And we are not concerned because owner is a company. We know that
Yes.
we can recover.
Yeah.
If it is a person, then it is difficult.
That is what they have already paid, I think. Oh no, you have paid.
Hmm.
It থাকিব দিয়া ইয়াতে। কিবা আছিলে নেকি আৰু? নাই।